Just want to be certain the members have the memorandum, right? Okay, thank you.
Thank you, Chair. If I could just add to what my colleagues have said. It's been mentioned that in Gauteng, for example, the caseload of legal officers is 800 files, which is not really manageable. Also been mentioned that our funding comes in part from the Fidelity Fund. Our funding, in fact, comes from mentioned that our funding comes in part from the Fidelity Fund. Our funding, in fact, comes from registered practitioners and then also from the Fidelity Fund. Now, we have a major problem in collecting levies from our members, principally because we do not have an appropriate regulation or statutory measure that is effective. And what we would like is for us to have the power to suspend the registration of or the accreditation of a practitioner while they are in arrears. It's a fact that since 2019, the Legal Practice Council, this goes back to before certainly my time on the Legal Practice Council, has from time to time experienced the growing pains of a brand new act. The LPA was a virgin act. It wasn't a successor to another act. The first act that regulates the entire legal profession. And obviously a new act like that is going to experience growing pains once it is in force. And the Legal Practice Council has since 2019, from time to time, submitted proposed changes to the act. And it is my understanding that not one of those amendments has been taken forward by the incumbent Minister of Justice and Constitutional Development. Now, one of those law reforms is the one that constitutional development. Now, one of those law reforms is the one that against members who, although in practice balk at paying an annual levy, which is a fraction of what members of the General Council of the Bar pay to that voluntary association. My levy to the Legal Practice Council is less than 5,000 Rand per annum. It's not a big amount. And yet it is not paid. I pay, but it is not paid by many. The other structural difficulty we have is that the amount that we receive from the Fidelity Fund is an amount determined by the Fidelity Fund in consultation with us. Now, when you don't know from one year to the next whether you're going to get 200 or 300 or 350 million, it makes it very difficult then to take additional staff onto your fixed establishment to act as legal officers and to carry out the other parts of our mandate. So those are two significant difficulties in the path of the effectiveness of the LPC. Thank you, Chair.
Thank you very much for that presentation. I would encourage the members to look at the memo because there is quite a lot of information therein as well. I'm going to ask some questions which are contextual and forgive me if they sound stupid, but I think they important. And let me say upfront where I am going with this, so that you know. I believe, and you are welcome to disabuse me later, that there is a problem of perhaps a saturated legal fraternity in terms of people that are out there in the system. There are too many lawyers relative to the people that can afford the services of a lawyer. And lawyers are struggling to either find employment or to keep their law firms profitable. And I believe that cottage industries develop as a consequence. In other words, pursuing rough matters exclusively becomes a way in which law firms make money, and pursuing medical legal claims becomes a way in which law firms remain profitable or are able to pay salaries or even of just the founder, him or herself, of that law firm. So it becomes a way to make a living. And that provides a perverse incentive for unethical behavior. That's where I'm going with the questions I'm going to ask you, so that it's clear. So, do you have information on what proportion of law firms are profitable, are basically able to pay their own bills, in effect? Do you collect that information?
No, Chair, we don't. And the main reason, Chair, is that when we do the audit, when we receive the audit reports of the law firms, the Act requires us, Chair, to only look at the trust account audit, which looks at the money that is relating to clients only. So that audit does not determine when the lawyer has paid his own fees, how much is remaining for him or her to remain profitable. The law does not require us to look at their business accounts or their business audits.
All right, so that's the first question. The second question I have is, do you have information on either the number of law firms or the proportion of law firms that only pursue these kind of claims? Only, that is, well, the most popular is the road accident fund. Do you have that information? In other words, somebody is a RAF lawyer, basically.
That one
No.
also, Chair, I don't think we keep records of that as to who specializes only in RAF matters. Many law firms that do practice RAF matters will also practice, will especially small law firms, or your general small law firm will have many practices. It will not be necessarily a specialized law firm in terms of RAF matters. And many other law firms, guy will have 2 or 3 RAF matters. So it's very difficult to keep an account as to who does exclusively what.
Okay, thank you. So would I be way off the mark if, as it, for a lay person like myself at least, think that there are law firms that have become expert at handling RAF matters, and there is a network of not just law firms, but medical and other related experts they work with all the time, right? In other words, we find a potential claimant, they go to Dr. Mkize, not our honorable member here, they go to Dr. Mkize and they go to expert so-and-so, and that a report is compiled, and that between all of these people, it's actually a significant part of their business, generally. Would I be off the mark? And as a linked question to that, have you investigated or at least had insight into the extent to which you have such scenarios? In other words, do you have cases where, and I'm imagining if I'm a judge in Pretoria, where most of these, there's always a medical report by Dr. Matiwane, and in the context of the RAF, because I really took time, I've read about 38 to 40 judgments on SAFLI. In most of the matters, genuinely, the RAF does not pitch, right? That says to me, if I know that, and I'm an attorney, and I know that they might not pitch, I'm always going to go to the same person to give me the same assessment that says a person is potentially going to lose future income of X amount, and I know the RAF won't be there, and we will get the default judgment because they're never there, right? And in that way, even though your report says only X amount, and I'm going to ask my last 2 questions, and I'll give the members. it's possible that those who successfully do this actually get to make a lot of money on the basis of what the Contingency Act allows.
Oh, Chair, I think you are correct. Let me first try and, as you mentioned, disabuse you of the idea of the cottage industries. Yes, there is a significant number of practitioners who enter the field, especially RAF-related litigation. I think it's one of the slightly easier fields to get into. Medical negligence, not so much, because I think that requires a lot more, deeper skill and understanding. But I think you need to take one step back. The reason why those, if you want to call them cottage industries, come into being is because there's a bigger problem in the environment, right? RAF claims cannot exist if accidents do not happen. And we cannot dispute the fact that these accidents do happen, right? And if these accidents do happen, surely the client or the victim does deserve to be compensated. I mean, that's something that's in our law from time immemorial, that you do need to be compensated for the damage that you incur. What level that damage needs to be is a different discussion, and I think maybe that's the one aspect that the CEO of the RAF is really trying to push, is in terms of that legislation, and I'm not going to express my opinion on that. But yes, those industries do come into being. I think the bigger question needs to be, when you talk about, I mean, you didn't use the word, but you kind of hinted at almost syndicates developing, right, between legal practitioners, medical practitioners. There might be some of those cases, right? But again, if you look at the statistics that we presented to you of legal practitioners who are struck or suspended because of that kind of unethical conduct, it's really a very, very small number. And yes, I mean, from experience, I can tell you that a lot of these claims, especially the RAF-related claims, also present before the Health Professions Council in the form of the RAF Appeal Tribunal, which looks at the severity of the injuries before the client can be paid for general damages. And yes, you are quite right that you will see the same medical practitioners presenting reports. And as in any other industry, you've got ethical medical practitioners and you've got unethical medical practitioners. The fact that you've got one medical doctor who continuously presents reports does not make him unethical. He saw an opportunity in the market and he took the opportunity. It's business. These are business people. Lawyers are business people. So to say that you've got the same people doing these kind of claims is problematic, I don't think I can agree with that. What becomes problematic is if they start entering into some kind of unethical arrangement, and I know of instances where this has happened, where legal practitioners will tell doctors to amend their medico-legal reports. That is wrong. And those legal practitioners should be reported and should be struck or suspended. But to take an opportunity that's in the market, I don't think there's anything wrong with that.
I can just add to what Ignatius was saying, is that there's a code of conduct on how legal practitioners have to behave and have to comply with. Highest ethical and integrity standards are espoused, and the same goes for the medical practitioner. We would be expecting that. I'm using the same person, but it's not. It doesn't imply anything. It simply means that I trust his or her expertise, and that's why maybe I'll go back to the same person.
Chair, if I may, I think it was the Deputy Judge President Sutherland who commented that the number of matters which are dealt with on an unopposed basis does not assist the process, because if you have medical practitioners appearing regularly as expert witnesses, but there is proper opposition. There's an expert on the other side. There's counsel on the other side cross-examining. Then, if a medical practitioner is not doing the job properly, they will be discredited through that process. But if they're continuously pushing against an open door in the sense that it's only their report and their version, and there's no one there to test it, leaving it almost to the judge to look into the cogency of the opinion presented, that doesn't properly test the expert. But I agree with what my colleagues say, that there is obviously a specialization in people who appear in court, just as there are with accountants. There are many accountants who will never appear in court, and there's some who will appear regularly as forensic accountants. That's not per se a problem. The difficulty is if they are not subjected to proper scrutiny.
Chair, just lastly on your saturation of the legal profession, we do believe that the profession is saturated, and you see this when it's the annual requirement for audit reports. The law firms are unable to even afford the 30,000 to get a chartered accountant to do their audit reports, because the little money that they received, they either pay rent or pay their staff, and you also have a lot of law firms which are asking us to exempt them from submitting audit reports because there was nothing. There's like less than 10,000 that flew into the trust account. So when we get those bank statements and we see that there are law firms which really don't make any money for many years, and they constantly are asking us to exempt them. But Chair, with that information that we have, the LPA strictly says that our mandate is to enable access to the profession. That has been my problem as the EO, to say we see about 6,700 people sitting for exams every year. Where are they going to get work to sustain themselves? But there's not much I can do about that, even to advise counsel, because the Act says that we must enable access to the profession, and that is what we are doing based on what the Act requires us to do, Chair. Thank you.
All right, thank you very much. So we are going to take a break at some point. My advice to you is that during break, discuss amongst yourselves who's going to handle which questions, because we will be here for a very long time if all of you take a stab at the question, because we also have lots of members here. I'm just going to make a statement and then ask my last question. And that statement is that, so I just forget the judgment, I'm going to find it, that the claimant against the road accident fund was a young person born in the 2000s, had done, I think, N1, N2, I'm not sure, and I'm old now, this in terms of grades. But anyway, this person passes a matric competently. They have an accident when they are in grade 11. The following year, so they submit a claim. The following year, they write their matric exam and they pass. And they get a tertiary qualification mark, right? I'll say metric exemption. I'm old, sorry. They get a metric exemption. Yeah, okay. Bachelor pass. They get a bachelor pass, right, or an equivalent. And the particulars of claim now state that this person went to a TVET college and did well in their first year. But this claim is continuing, right? There is a medical practitioner who has done an evaluation of this person, and they've said this person is brain damaged, right? And therefore their prospect for earning an income in future are poor. There is no RAF attorney in the hearing. Now the judge is arguing, literally is like asking questions. I'm looking at your submission. How can this person do well in their exam and also do well post school? And you are here telling us that their prospects of making an income in future are poor because they are mentally impeded. Which said to me, this was a bogus claim, and that's what the judge, they couldn't sustain the thing, but the submission is there. What I'm trying to get to is I'm not saying people enter into these professions in order to crook the system. I spoke about a perverse incentive. And the perverse incentive is that I know if there'll be nobody to defend the matter, I can make any claim. Chances are it's going to be accepted. Right? That's where I am basing my opinion on, because SAFLI is littered. I would say about 40% of the cases that are there are RAF cases. And I've taken time to read lots of judgments, short ones, long ones, all the way to the Supreme Court of Appeal. And this appears to be a constant problem, where the RAF does not appear. And some of the claims where the RAF does actually argue the matter, the claim is preposterous. So that's the first thing I want to say. The second thing I want to say is that if we assume that in order for someone to lay a complaint with the LPC, they have to know about its existence and its work, and that we can make an assumption that a fraction of South Africans know, the majority of South Africans don't know, and that it is plausible, therefore, to say the cases that you are reporting on are the cases you know about and are on no indication of the extent of the problems that you've. Can we agree on that? That there is no, you can only report on what you know. And if we look at all crimes and cases of misconduct, they get underreported. And that the problem may be bigger. And if we had the tools to examine a sample of 500 cases before the RAF, in all, you might find that there is this. And therefore, it is possible that this cottage industry actually exists, where people milk public funds in this way. I'm not accusing anyone in particular. I'm just trying to examine the facts. The last point I want to ask you is pertains to so I've had a look on that encourage members to look. I think it's page 15. Where's that table in the memo? And I noticed that there was an explosion after COVID-19 of cases of misconduct because they went from how many in 2022? Please assist the committee with the dates, the page number. But anyway, and that says to me we now have an exacerbated problem, because you ordinarily have law firms that are struggling, then they got affected by COVID and they potentially are struggling even more. We will, let me just give the members an opportunity to ask. The time is past. I want us to take a break at 11. So I'm going to give Honorable Skosana and Honorable Madlala.
Sorry, Chair.
Sorry. Oh, sorry.
Proposal. Chair, can I... Thanks, Chair. Good morning to colleagues as well and LPC. Chair, I just want to make a proposal that I think it will help us to manage time. I'm not sure, Chair, but I wanted to propose that why don't you give each member maybe, let's say, 10 minutes. If you count that, it should be about 2 hours and 10 minutes, the exchange between them and LPC, and then we move on so that we don't lose questions in between. Thanks, Chair.
Proposal accepted. So what we will do is we will give Honorable Skosana and Honorable Madlala. So here's how we'll do it. So Denzel is going to start timing. You get an opportunity to have an exchange with the LPC. So the 10 minutes is not for the asking. The 10 minutes is for the entire conversation. How many questions you manage to get in has to do with how concise you are with your questions. One. And secondly, may I please ask colleagues, amongst yourselves, you need to pick. Otherwise, the members are also going to get frustrated when the answers come from many different people. Is that okay? Can we proceed on that basis? Thanks, Honorable Maduna. Honorable Skosana, your 10 minutes begins now.
Thank you, Chair. I'm sorry that I came a little bit late here. But be that as it may, we are again back to the road accident fund issues, which reminds me of some time ago. If you remember, Chair, there was Ian Stokes who left with millions of rands. Investors put money into his account. He was paying claimants in advance and, a percentage. You make a claim at RAF, he pays you because he knows that you sign, that you will be paid in a year or two from RAF. Then we'll pay you the remainder, around 16%, if I remember well. Now, is it Ian? Is it Ian, if I remember well? I'm sorry? Ignatius, yeah. I've listened very attentively. It's unfortunate that the LPC as well dominates by the JCB. LPC has just become
sorry by that, J?
GCB.
GCB.
Yes.
What is that?
They'll answer. They'll know what I'm talking about.
No, remember.
I will tell you.
Okay.
It's General Counsel Bar.
Okay. Yeah. No. Yes. I always do that when
okay.
there's an abbreviation.
Okay, thank you.
Yeah. No. Because we streaming.
Sorry, Chair. LPC has become another terrain used to settle scores and target legal practitioners, advocates that are outside the fold of GSCP. What happened when this LCP started? Mainly dominated by GCP members, in particular whites. Why did the LPC condemn Pabasa for certain charges against Mpofu? I'm talking about the recent case, when themselves withdrew for the same reasons. Chair, where I'm going, in South Africa, there's a settling of political scores here. Among other things, jealousy as well. I'm going to be frank. Is the LPC not entirely composed of GSCB? That was my question when I mentioned this. Of advocates to the exclusion of advocates from other bars association. Is this not compromising its integrity as a regulatory body? What do you say to the accusation that LPC is colluding with JSC to ensure that association like Pabasa and the National Bar Association are excluded from JSC so that only advocates from the GCB can be involved in the appointment of judges? The LPC seems to be slow to pursue charges against white advocates and quick to pursue charges against black practitioners. What happened to the charges against Helen's SC and Jubed SC convicted of lying to the Namibian authorities? Is it true that LPC has not finalized its procedure regarding the silk recommendation and that it seems to recommend only those from the GCB? Now, let me just ask this as well. The issue of RAF, when I look at the presentation which we received, these 101 or 102 firms, why they were not named on this presentation? Why they were not named? And I can tell you, it's for one reason. They are protecting big firms here. The issue of medical claims and the issue of lawyers, as Ignatius was saying to us here, that some of them paid back the money, that 350 million which was erroneously being paid to them. I'm not buying that. If only the numbers which they gave us here, that no, some of them, the double payment was, I mean, it's ethical for you, before even being pursued, to pay back the money, because you can see in your account that there's money which you don't deserve. Those duplicated payments, we know what happened. Some big fish were involved here. Some of them, I'm seeing, I saw that there's 10 of them or so. And the issue of I think one of my colleagues asked about the interest. And the answer is not convincing, unfortunately. You know, that lawyers are business people. Yes, be a business person, but be ethical. Be a business person, but be ethical. And there's a lawyer for that matter. I mean, we've seen judgments in this country which leaves much to be desired. We know for a fact that sometimes judges think that they are, in fact, they are law unto themselves, some of them. I'm going to be frank here.
Honorable Skosana, so I'm not stopping you. I'm just giving you a time warning.
Yes.
Because
I'm aware.
you need to get proper answers, right?
Yeah, thank you, sir.
And we're going to run out of time, and then it's going to be a problem.
Yeah. Let me finish by saying, to the Legal Practice Council, that it's unfortunate that the milking cow is road accident fund for even these so-called big firms, you know, like your Wenzel and Weber, you know, who've got almost 500 lawyers or attorneys, and these Bowmans and Bowmans or whatever the name is. But I'm still saying, Chair, that please, in this presentation, they must name these lawyers, these firms. Thank you, Chair.
Thank you very much. So we invited. Thanks.
Sorry, Chair. Sorry, Chair. My last one. Sorry, Chair. What is the use of chasing lawyers who are not practicing in law, who are not practicing in any bar, and say you want to strike them off the roll? Thank you, Chair.
Thanks very much. So I'm going to say we invited the LPC and we'll stop the clock. It's at 8 minutes. So I invited the LPC here for two specific reasons. And I'm not saying they shouldn't answer the question. If they're comfortable to answer it, they can. Because we took two presentations, or in one session in this room, with the health minister and the health committee about medical legal claims. The second, we've had numerous encounters with the Road Accident Fund on precisely these matters that we're talking about. We then agreed in that meeting that we will call the LPC to account. In my briefing to the LPC, I asked them to focus on those two matters. I'm saying this because in the early part of your questioning, you focused on issues pertaining to Advocate Mpofu, I'm assuming, and so on. I never asked them to prepare for that. I think it falls outside the brief of what we've said, but if you're comfortable, you're in a position to answer that question, please do. I just don't want to come across as protected. I just want to be clear about how we got here, Honorable Skosana, but I won't direct them on whether they should answer. If you're competent to answer that question, please answer that question. Thank you.
Thank you, Chair. I think I will answer most of the questions by Honorable Skosana. The LPC is definitely not dominated by the GCP Chair. And I say this because on my opening remarks to the committee, I did clarify that out of the 23 council members who make up the National Council, only 6 are advocates. So if you do the maths, you then have 17 who cannot be a member of the GCP because they are non-advocates. That's the first point, Chair. The second point is that other bars are excluded. That's not the case, Chair. The election of the provincial of the council members, either for national or provincial, is a democratic election, every practicing legal practitioner is allowed to vote and or to nominate and also to vote for the member they want to be either on the National Council or the Provincial Council. Chairperson, on the issue of the collusion with the JSC, I am not aware of such a collusion, Chair. I am aware that there was a complaint by Pabasa that we need to come up with the rules of nominating LPs who need to serve on the JSC, because the status quo has always been some members of the advocates profession to be members of the JSC. We have actively, although maybe it could have been delayed, Chair, put together a process where those members who go and represent the legal profession at the JSC will be a nomination and an election by the members of the legal profession. So the only thing, Chairperson, is that that process has not yet commenced. I understand, Chair, that the matter of LNSC is still under investigation, but I will not speak on that because that is a provincial council matter. But I know that the complaint was received and it is being investigated. The silk recommendations procedure, Chair, the status quo has been going on up until last year, when we submitted the criteria for the nomination of people to become silks. And that now included attorneys becoming senior attorneys. The problem that we had, Chairperson, which we have sent numerous times to the Minister, is that on the new panel that is proposed on the criteria, there was a member of the panel was supposed to be a senior attorney. And if you look at the past, we've never had anyone becoming a senior attorney. So we then said to the Minister, can you please appoint 2 people to become senior attorneys so that we are able to then implement the process of nomination and recommendations of silks people. But that process, Chairperson, has been delayed at the Minister's office and not by the LPC. If that recommendation to the Minister had been implemented by the Minister, Chair, we will be running with the nominations and recommendations of members that are requesting to become silk as early as this year in 2025. The names of the LPs or law firms, Mr. Skosana, which were on the list, this list we received in 2020. It's a list which we dealt with 4 years ago. We will have to look for that list, and we can definitely provide it to the committee. And lastly, Chair, we don't strike off non-practicing lawyers. And if there is any instance where the Honourable Skosana is aware of, please let me know, because then we'll have to look at the reasons why they were struck off. Non-practicing legal practitioners, Chair, do not pay levies, and they are barely brought to us as people who have conducted any misconduct. Barely. But if there is any non-practicing lawyer who's brought to us, we do investigate. But I don't remember in my 6 years at the LPC, Chair, where we struck off a non-practicing legal practitioner. Thank you, Chair.
Thank you very much. Honorable Skosana, your 10 minutes is expired.
No, I want to just make a follow-up one, because I don't want to be misquoted, Chair.
You want to make a correction?
Yes. I just wanted to make a correction. No, it's fine. Mazala is fine. Yeah. Oh, you can borrow me. Thank you. Thank you, Mr. Maduna. Now, the issue, Chair, which I've raised here, as I said, like he's answering the issue of Helen's and Jubed. To say the matter is being investigated is not enough for me. I'm honest on that, because I've been hearing this thing, as I was saying, in other committees, that some matters are being investigated from 2011. There's no time frame, there's nothing. And in fact, as I said, I'm sorry I came a little bit late. I don't even see the chairperson of the Legal Practice Council. Maybe they've explained why. And the deputy is not here as well. Mr. Selega is not here. I'm not sure whether the deputy is here. I'm just saying, those are the issues that we have to be taken serious, Chair, as well. Because I guess that in all the people who are being called to come here, they come here with their chairpersons. You know, for me, or a deputy, for me, I'm not sure why the perhaps they've explained earlier. Thank you.
Okay, Honorable Skazana, thank you. So I had actually a meeting with Advocate Seleka. If he had been here today, so he's acting as a judge. So if he had come here today, that matter would have had to be postponed for a significant amount of time. And we cannot postpone this hearing until such time that that one person is here. Because we'd already postponed already. They were supposed to be here earlier. So he's acting he's sitting on a case today as we speak. That's the long and the short. Thanks, Honorable Skosana. Can I go to Honorable Matlala?
Thank you, Chair. To the LPC, the first question is, or maybe what we've been gathering through the interventions or the meetings we've had on the two referred institutions, is that they would say we have referred this law firm to the LPC. And it would appear that there's a delay in terms of then finalizing complaints that would have been referred. So I want to understand what is the reason for the delays. Well, number two, is there a staffing what is the status of the staffing capacity at the LPC? What are warm bodies versus funded vacancies? For example, do you have a full complement of whoever is responsible for processing those issues? Also, what happens in between the time when a person or a firm or an entity has lodged a complaint and the time that it is finalized? So is there a probability that the person could be continuing operating and continuing with the similar misconducts in between that process? In terms of protecting the consumers or the clients, does the LPC have a database or a systematic way in which a person, civilian, can verify registered law firms, people that are proper? You know, if someone, Madala says, I'm registered, I'm a legal practitioner, can a person go and punch into a system to verify so that they don't get abused by any other law firms? What is the status of unresolved complaints as we speak? How many complaints have been lodged? How many are unresolved? And maybe we can also say how many have been resolved, let's say in the past financial year or so. There is also an issue of which contributes to the delay of the time lapse in an event that an owner of a law firm or a practitioner is deceased. My understanding is that then the files are transferred to the LPC to deal with the trust issues and ultimately the files get reallocated. In that process, do clients who are owners of those files, do they get communication from the LPC to say, please be aware that your matter is on pause because there's a deceased, because your representative is no more and we're going to conduct this, whatever needs to be done by either the curator or whoever is involved, up until the matter is finalized? And how efficient is that process to ensure that the delay is kept? I think I've taken 4 minutes, Chair. Can I do follow-ups in the remaining 2 minutes? Thank you.
Thank you, Chair. We will split the answering, Chair. We won't deal with the same questions. Just on the funded bodies or the number of people, the LPC is assisted by 400 employees. We have discussed in the past year the requirement to get more funding so that we can hire more staff. And currently what we require to subsidize our current staff is we require staff to the tune of about 14 million a year. So until we are able to secure funding from the Fidelity Fund, which will be able to fund these additional bodies, we are still working with reduced capacity, and we are trying to work with what we have at the moment. And I'll just jump to the last question, Chairperson, from Honorable Madlala on the verification of law firms. We have tried even on our social media to alert the members of the public that on our website we have an interactive and live database of both the legal practitioners which are supposed to have fidelity fund certificates whom the member of the public can pay their funds into, and also the law firm. So that information is updated on a live basis if you log on into our system. We also, when our LPs appear in court, we ask them to have digital ID cards which show as and when it is shown to maybe the magistrate that the LP is in good standing and is registered with the LPC. But we still find, Mr. Madlala, that there are instances where members of the public are still using people who pose as lawyers and they are not. But we're trying to reach as many members of the public as possible to alert them of the existence of our website, which can give them information regarding all LPs which are in good standing and which are allowed to practice as legal practitioners. I'll allow Mr. Brill to answer the issues on disciplinary cases.
Thank you, Chair. So, yes, I agree. There are delays in finalising complaints. I think the biggest, and we did address it to some extent in the memo, the biggest issue is the capacity. If you consider the number of complaints that we receive annually, so for this year alone, January to basically 16 June, we received 6,700 complaints, right? So annually we receive around about 12,000 to 13,000 complaints. We manage to finalize around about 10 to 11,000 complaints a year. So unfortunately, our backlog in terms of complaints are growing, which is very concerning, obviously, to us. And the EO has addressed the measures that we're looking at to improve that turnaround time. I think the other question related to the curatorship process. So obviously there's curatorship for deceased or suspended or struck practitioners. The deceased practitioners, unless there's a trust deficit, if there's money missing from the trust account, those matters are generally dealt with fairly quickly. We tend to try and not appoint a curator on each deceased matter unless it's absolutely necessary. So depending on the amount of money in the trust account, and depending on whether there is another member in the firm who can take over the management of the firm, we will decide on whether we need to appoint a curator. Once a curator is appointed, in terms of the court orders, the curator and the curators in general are the directors for the provinces. So I cannot make a decision on my own on payment of a claim against the trust account. I need to have permission from the Legal Practitioners Fidelity Fund Board. So all claims that come in need to get approval from them as well. And this is just to safeguard against, abuse. You really don't want Ignatius Brill on his own to make all the decisions on all curator matters. I think it's just a safeguard. And the claims go through a verification process. So the client needs to show us that they are the beneficiary of the money in the trust account. So in short, if the accounting records are up to date and correct, then those matters are finalized fairly quickly.
Thank you. I want to understand as a follow-up, let me repeat the first question. How many are unresolved? How many unresolved matters you're sitting at? In your response, you said about a year you get about 12,000 and you resolve about 11,000. So you're saying your performance in terms of resolving issues is at around 90-something%. So the backlog, where does it come from? I want to also understand that if you resolve it, if your performance level is at 90+%, where does this backlog come from? Is it from legal issues, or where exactly does it come from? But also, what is then your turnaround strategy around that? And maybe lastly, besides dealing with the legal issues and the backlog, what is the time frame within which you have set yourself to resolve matters? Whether you meet that or not, I think that's second. I just want to know if you are saying that when we receive a complaint, from the time it's logged in, we have got 30 days or within 60 days or within 90 days in a normal functional environment. However, currently we maybe are not able to meet that, or whatever is the case. Thank you.
If I may respond, the backlog comes from the number of complaints that we do. So every year it adds on a small bit. Some years is good years. The COVID-19 set us back substantially, and that we just never could get up to date subsequently. You must understand, we don't have all the capacities for conducting virtual meetings with all the committee, the complainants and so forth. We struggle to conduct meetings virtually. So the current amount of open complaints as it stands at this stage is 23,164. I think the oldest one is dating back to 2016 at this stage. So still from the Law Society's days. Time frames, in terms of the Act, we are obliged to provide the attorney 30 days after we send them the letter to reply to the complaint. They don't always comply. We call it a reminder, give them extra 2 weeks. The complainant gets opportunity to respond to the comments. We will then, of course, give the complainant also 30 days. So between all of this until it's ready really for the agenda, that's if everybody responds, it takes about 3 to 4 months for the whole process to run, the investigation. It's then placed before an investigating committee consisting of a panel of attorneys or advocates, depending on who is the respondent in the matter. And that will depend on the workload of the legal officer. That can be done or should be done within 2 to 3 months. Our longest delay at this stage, unfortunately, is the trials. To get the matter enrolled for trials, trials take, unfortunately, a bit of more time. People play around, attorneys and complainants. Once a matter is set down, somebody is ill, the car broke down, and we have to re-enroll the matters. So unfortunately, there is long delays, specifically with the enrollment of trials. And what we're currently doing, the EO has started a project. We have got funding that we are appointing. We have advertised already. We've started conducting interviews on a project to specifically help with the backlog in trial matters. So all the provinces will be getting between 3 to 1 legal officer to help them. We're going to test it out for 6 months. If it works, then of course we'll continue with it at least for another 6 months. And the whole purpose is really to work down the backlog, specifically in trials.
All right. Sorry.
Thank you, Chair. Just last bit, Honorable Madlala, just to note that the LPC is disciplining lawyers. Everything that you can think of that a lawyer can try to get out of being disciplined gets thrown to us at the LPC. You'll find responses not coming for 4 months in a row, and each time we get a letter from the doctor that the LP was sick or was unable to attend an investigation. I think this could be the most difficult profession to discipline, because we are dealing with people who know how to work around the law to work in their favor. And you'll find that there are instances, Mr. Madlala, where we have actually struck off a lawyer, and the person has not even responded once to a letter of sent to him by the LPC. And then when the matter then goes to court, then he starts saying to the LPC, well, I was not part of the investigation and the disciplinary. But why didn't you respond to all the letters? When we informed you of the sitting, you were not there. Then the panel then made a decision in your absence. those are all the problems that we have to face. And then the process of us applying to court for a strike-off is further delayed because the person is now coming in and defending the matter at that stage. So if we were maybe disciplining a normal, person, not a lawyer, it will be quicker. But we try to have our matters finalized within 6 months, unless there are issues that are brought to us by the respondents. Thank you, Chair.
Thank you very much, Honorable Madlala and Honorable Skosana, for this phase, and thank you to the LPC. So we're going to take a 15-minute break and reconvene at 11:15. I know. I'm sorry. It's been a while. Human rights break.
Inquiry, how we can actually improve the efficiency, because it's having a huge impact on the justice system. And then you mentioned that you've got 800 cases per one caseload per one worker in Gauteng. I mean, that's an incredible amount of cases. It's worse than the Hawks. And how do they decide, and how do you decide which case gets prioritized? Is it in chronicle order, or is it based on value, whatever? And then just to capacitate me, and I'm certainly no expert, does every accident lead to a claim? How is it calculated, and what is the average claim? And then just in terms of that 350 million that was paid to 101 lawyer firms, am I correct to say that they were sitting in that money and they didn't phone back the next day and say, we've got this money? Because either lawyers get paid a huge amount, and so if you work it out, it's about 3 million rand each. So surely every single one of those lawyer firms should have been disciplined, because to be sitting with that amount, if I get 3 million in my bank account tomorrow, I can't sit with it. I have to phone my bank and say, there's an error here. So surely, to only 12 people to be, I don't know what the exact figure was, to held to discipline. I mean, everyone should have been held to discipline. And the fact that they didn't pay the interest over, to me, that's just not right. And then just on a lighter note, in terms of the fees, you charge 5,000. I'm a member of SACA. We charge 10,000. So maybe you should double your fees. But just in terms of the fund, the Fidelity Fund, can you not add a certain percentage to that goes to you people? Is that not part of the way to get a funding model? Thank you.
Thank you, Chair. I just want to answer the administration part. On the funding model, this is we are in the initial discussions on the funding model. I'm not sure if you are aware, in the Attorneys Act, when the interest was collected, 12.5% went to the regulation, and this is something that was scrapped when the LPA was introduced. And we are thinking that we need to have a serious discussion with the fund and the minister to bring back, because that could certainly ease our capacity problems and our funding problems. But I will ask Ignatius to answer all the other questions. Thank you, Chair.
Okay, I hope I noted them all. Let's firstly start with the problems at the judiciary. I think there's a major issue with the capacity of the judiciary. And I was very happy to see the media reports that the President has now actually awarded budgetary control to the judiciary. The fact of the matter is that there's been very little growth in the capacity of judges, or the number of judges, in the last 30 years. And it's just not kept up with the pace. So I think that is a prime area to start in capacitating the judiciary, rationalizing possibly where the courts are sitting. And I know JPM Lambu has made recommendations that there be a separate High Court established, for example, on the West Rand, to deal with, West Rand, you're talking about mines, etc., all of those currently going to Johannesburg. So the capacity there needs to be looked at. The one thing, and it's maybe not going to resolve the issue, but if I can abuse the opportunity, the physical state of the court buildings is a complete disaster. And I think Public Work needs to start explaining why these places are not maintained. Johannesburg High Court, for example, is actually a serious fire risk. But that's just as a side issue. On resolving the issues at the RAF, again, I don't really think it's the LPC's place to say, but if I may venture, capacity is a serious issue. It has been an issue probably for the last 20 years. I remember, I think I left there about 5 years ago. For the preceding 15 years, the claims officers had been sitting with file counts of around about 1,000 files. The capacity is not there, and that is very closely linked to the funding model. If you think about the fact that the funding comes from the fuel levy alone, I don't think the fuel levy can continue sustaining the growth in claims. And I don't think there's much of a dispute about that. So the funding model needs to be looked at. Obviously, the administration and management needs to be improved again, get proper processes in place, make sure that claims are assessed and investigated. I mean, there's numerous cases where the courts have said it is the duty of the RAF to investigate a claim. But that's not happening for whatever reason. So let's start there. Let's start investigating those claims. And you are going to curb this issue about the escalation of the settlement amounts. You're going to curb the issue of the fraudulent claims and the abuse of the system if the RAF simply properly investigates. Okay, yes, the duplicate payments. So can I just explain to you what happens, right? When an RAF attorney, a claimant attorney, receives money from the RAF, they don't get one payment per matter. The RAF makes a bulk payment, and very often the associated remittance is not provided at the same time. Yes, for firms that are smaller and don't have a lot of matters, it should have been possible for them to see that I'm getting money in that I shouldn't be having. If you have a substantial practice, and let me not mention the firm's name, but there's a firm that we're currently busy with suspension and striking proceedings. We uplifted in excess of 6,000 files from that firm, RAF claims. Now, if you're dealing with that volume of RAF claims and you get a payment of 10 million into your trust account without an associated remittance, you will not know what that payment is for. And then what you are expected to do is to retain those funds in trust until you can establish who the funds belong to. You're not allowed to touch it, right? And that's where the guys that we've been suspended and struck fell short. They touched that money. If you cannot identify, it must remain there.
Interest.
So I think I did address the issue about the interest earlier, and I think Mr. Pachane also addressed that. I think it's something that we do need to speak to SIU about to see if there's legal recourse for the recovery of the interest. The fact of the matter remains, as long as the money is in trust, that interest by law goes to the LPFF. That it?
Honourable Pisley, I thought maybe you're done.
Am I?
No.
Chair, I'm a disciplined member, so how much time have I got left?
Thank you very much. Okay.
Now, just some of my questions weren't answered. They're simple questions. You know, does every accident lead to a claim? How's it calculated? And then just a question I didn't ask, you know, do we know how many RAF matters are enrolled in the legal system at the moment?
Right, the number of matters enrolled in the legal system, I wouldn't be able to give you an answer. I can give you probably at a later stage a rough idea in terms of Gauteng, because there's very decent stats kept, but I don't have that answer. Whether all accidents lead to RAF claims, right, so that answer is maybe a little bit more complicated. So you need to distinguish between personal injury claims and your medical your claims for medical costs. So you might have instances where minor accidents, there would be, supplier claims. It used to be called supplier claims. So this guy goes to the hospital, it might be a bit of a bruise, and he gets treated and given some paracetamol and he gets sent home. Those could lead to supplier claims, and those are small amounts depending on the cost of the medical treatment. For other injuries sustained in accidents, there you need to distinguish between your general damages and the loss of earnings, right? Now we're not talking about deceased victims, right? On general damages, how that is calculated. Firstly, the RAF brought in, I think it was in 2008, the Amendment Act. And the idea was, I remember there was a CEO at RAF who used to always talk about the shame money. Okay, so most motor vehicle accidents led to whiplash injuries. We all know what a whiplash injury is, and those usually used to settle in the region of 40,000. So the RAF felt that those, it was called shame money because actually it was felt that person, there's nothing wrong with the person. So the idea was introduced to say, let's look at only compensating for serious injuries. Okay, and then there's a process to assess whether somebody is seriously injured. It's a link to the American Medical Association formulas that looks at the whole person impairment. So a medical assessment needs to be done from top to bottom, looking at the injuries, the effect of the injuries, and the potential future effect of the injuries. Okay, if your impairment reaches 30% or more, then you become entitled to general damages. There is a process, as I alluded to earlier, where the HPCSA by law has established an RAF appeal tribunal, which consists of medical practitioners who need to assess if there's a dispute about the seriousness of the injuries. And at that tribunal, a lot of the assessments have been turned down to say, but in as much as the doctor might have said it's more than 30%, it is actually not. The quantification of those damages, we used to call it the vleislijst, right? So it's a little booklet by Koch, looking at various judgments over the years where the courts have awarded damages for general damages, and then those get escalated by inflation, etc., and adjusted for amendments in the court awards, and that does become quite costly, right? And maybe just to comment on what you had indicated earlier, those brain injuries is a very, very difficult area to deal with. Very often, the brain injury that is sustained is not, or the effect of that is not apparent immediately. It might be that in many years' time, the injury starts causing negative effects. I do think I to some extent agree with you. You would see cases where the child is from a very impoverished background, and then the industrial psychologist comes and says, but this child would have become a mathematician or a rocket scientist, whatever you want to call it. And yes, the possibility is there, right? But realistically speaking, from a socioeconomic background, it's unlikely. And then what the courts do is to adjust for the contingencies, okay? So yes, there's a percentage possibility for you to have become this medical doctor or whatever. Let's say maybe that's 50% possibility. And now let's look at your current circumstances. They do all kinds of very nice actuarial calculations to come up with a contingency or the likelihood of the person having become that versus the possibility at the present stage. So it becomes very convoluted. And those tend to be the higher part of the costs or the damages that are awarded is the loss of earnings. Okay.
Thank you very much, Honourable Beasley. Honourable Nilmay.
Yes, good morning, Chairperson, colleagues here present, and the members of the Legal Practice Council. I want to make a comment first, and then I have about 18 questions, of which some have been answered. The growing crisis within the Road Accident Fund and the explosion of medical legal claims against the state raise serious concerns about the role and conduct of legal practitioners in these matters. Parliament and the public alike have become increasingly alarmed by reports of unethical practices, inflated claims, and possible collusion, not only among private attorneys, but also between some practitioners and officials within the Office of the State Attorney. As the statutory body responsible for upholding the integrity of the legal profession, the LPC plays a critical role in safeguarding both the public interest and the credibility of the legal system. It is therefore important for us to better understand what oversight mechanisms are in place, what interventions have been made, and what reforms the LPC believes are necessary to restore trust in this area. With this context in mind, I would like to ask the following questions. What steps, and this is generally on general oversight and ethics, I have 5 areas. What steps is the LPC taking to monitor legal practitioners who represent clients in RAF claims for unethical and exploitive practices? Has the LPC investigated any widespread trends of overcharging, fraud, or collusion in RAF or medical legal cases? What were the outcomes? What disciplinary actions have been taken against attorneys found of inflating RAF claims or engaging in unlawful conduct, which you did reply a bit previously to my colleague here, Honourable Beasley. But you can explain a little more. How does the LPC collaborate with the RAF, SIU, and Judiciary to detect and prevent unethical conduct in RAF matters? My questions are more developmental. Is there a register of firms or practitioners under investigation or sanction for misconduct in RAF cases? Can this be made public in the interest of transparency? I'm now going to go on to the medical legal concerns. What measures are in place to ensure medical legal reports submitted to RAF matters are credible and not falsified? Has the LPC engaged with the Health Professionals Council of South Africa to address collusion between lawyers and medical practitioners? What is the LPC's position on alleged syndicates involving legal practitioners, doctors, interpreters, inflating medical legal claims? The last 2 sections, this is the client protection and trust accounts. What mechanisms are in place to protect RAF claimants from lawyers who withhold or misappropriate their settlements? How often are trust accounts audited, especially for firms dealing heavily in RAF cases? Has the LPC received complaints from clients about delays in receiving RAF payments from their attorneys? How are these resolved? From a systematic and legislative alignment, does the LPC support legislative reforms to tighten control over medical legal claims and legal fees in RAF matters? Has the LPC provided any submissions or advisory opinions on recent or proposed changes to RAF legislation or administration? What is the LPC's view on the proposal that the RAF move towards a public healthcare and managed care model for treatment instead of lump sum payments? And then finally, the last section, which is more on data monitoring and accountability, is can the LPC share data on the number and nature of RAF-related complaints received in the last 5 years? If not, we can look at that later. Are these guidelines or benchmarks for legal fees? Should I say, are they guidelines or benchmarks? Now, there is the Act that you were saying on which mentions contingency fees. So are these guidelines or benchmarks for legal fees in RAF cases to prevent abuse of contingency fee arrangements? You did speak about that earlier, but basically, we're looking at benchmarking. What improvements can be made to ensure that justice is accessible and that legal practitioners do not exploit the road accident victims? I have one last question, and that is the issue of, and which is a very serious issue, which I mentioned in my opening statements, is what steps has the LPC taken to investigate reported cases of collusion between private legal practitioners and officials in the Office of the State Attorney in RAF and medical legal matters, particularly where inflated claims or intentional non-defense of cases have been alleged? Thank you.
Thank you, Chair. I will try and address some of the questions. How we monitor law firms is that we depend on the audit or accounting profession who are required annually to audit the trust accounts of the law firms and to provide us with an opinion of whether the accounting records are in order and whether there is a clean audit for each law firm. Now, we have in some instances found, Chairperson, that there has been collusion between the law firm and the auditor, and in such instances we do report those matters to IRBA to investigate further. But also you will note that you'll find that the auditors are not clear on the fees payable to legal practitioners, and if the LP says that this amount is due to me as my fees, they will then audit and give a clean opinion on that audit, and they will not necessarily be able to pick up what is overcharging and what is not. Also on the list of those LPs that have been found guilty, there is an updated report on our website, which is lpc.org.za, which updates every time there is a disciplinary outcome that is communicated by our panel, and it is updated on our website as and when it happens. So that list is readily available, but what we don't do is that we don't register the matters that are brought to us as complaints, because it is not all the time that a complaint leads to disciplinary action or leads to a fine or to a suspension. So we wait until the process of investigation and the DC is complete, and then we publicize that information. And especially, Chairperson, when the person is struck off the roll, we make sure that we communicate that information on the community papers where the law firm is practicing, so that the community is made aware, and anyone whose file is in that law firm is able to come to us and retrieve their file. So that information is available, and it is updated as and when there are outcomes communicated to us by the different disciplinary bodies that sit in all 9 provincial offices. The trust accounts, Chairperson, they are audited annually unless there was no movement in the trust account, and then you submit a full bank statement for the 12 months that shows that there was no movement in the trust account, and then you are then able to be exempted from doing an audit report, so that you don't spend 30 or 40,000 on an audit report when there was nothing that was deposited in your trust account. I'll allow the officials to answer the rest of the questions.
On the collaboration with RAF, SIU, Judiciary and HPCSA, I can mention that we've been trying to enter into an MOU with the RAF, I think since beginning of last year, and we've not had any positive response from them on the MOU. On ground level, though, we do cooperate very well with staff from the RAF. You know, especially when it comes to complaints, to check whether capital has been paid, on curators matters, to check, you know, if there are any fees or capital still due to the trust account, and to assist us to identify trust creditors. So on the ground level, there is very good cooperation. I think what is lacking is a proper MOU to govern the relationship. The proposed MOU looked at things like the channels of communication, setting out the process for bringing complaints to our attention and speeding up those complaints, because I think we do realize that it is important that these matters get addressed fairly quickly. With SIU, same thing. We've got a very good ground level relationship. You know, where they investigating specific matters, we are in continuous contact, and it's working very well. With the judiciary, and let me talk about Gauteng, again, a very good relationship. I think judiciary is a little bit different. You're not going to enter into an MOU with judiciary. But generally, the judiciary in Gauteng is very accessible to the LPC, and we cooperate well. They do tend to give us preference in terms of bringing our matters to court, because they understand the importance of finalizing these suspensions and strikings.
Sorry, may I ask, on the MOU, what's the difficulty with it? Have you guys had meetings? Just help us understand.
I think we've had 3 meetings, if I remember correctly. And the feedback was simply that it's waiting for the executives. I've not had any formal communication about what the concerns are with the MOU. Nothing of that sort.
Okay. Which and I'm not looking for a name, which official have you been liaising with? In what role?
I think it was the chief strategy officer, if I remember correctly. She was at one of the meetings. I'll have to check the minutes, though. Let me not commit to that answer. I'll have to check the minutes.
All right, thanks. If you can just assist us with that information, because it would seem to me, given the complaints against attorneys and the RAF's own version of its experience with attorneys, the most important thing to do in that is that MOU to expedite action against anybody who may be acting unlawfully or unethically, especially to the detriment of claimants and also taxpayers. So could you please just assist us with that? Because I think there needs to be an arrangement in place between the LPC and the Road Accident Fund on these matters. Otherwise, we are not serious about dealing with the problem.
Okay.
Sorry, I just wanted to add, Chairperson, that on the collusion of attorneys and state attorney and all that, and RAF officials, I don't think we will have a capacity as the LPC, given our number of complaints that we are dealing with that are just looking at the conduct of legal practitioners. And I will think that that is the area that the SIU is strongly involved in. And they do at most times require our information from us, which we gladly give to them so that they can do the investigation. But I don't think that we will have the capacity to look at that, at those collaborations where fraud is being planned within all the different spheres of legal.
Okay.
I was going to say, Ignatius, maybe if you can also just touch on the issue of benchmarking in relation to contingency fees. You did speak about it in your presentation earlier on.
Right. I'm not sure if I quite understand the question about benchmarking on contingency fees. As I stipulated, the contingency fees is regulated by the Act. I think the important part is, as part of the LPC's mandate, is to look at developing standards for legal costs, and the LPC's fees committee is currently looking at establishing forms of what do you call it, like a standard kind of fee structure. Yeah, fee structure, which can then be communicated to the public and members of the profession. Because why that's important is that then gives you the indication of the calculation that needs to be made to establish your maximum amount under the Contingency Fees Act. In the absence of those guidelines, there is still the mechanisms of fee dispute committees, which the LPC has. So anybody with fee disputes can bring those fee disputes to us. We put it before a committee to investigate whether the fees are reasonable. There's also the aspect of the taxing master at the courts, who is empowered and mandated to tax legal costs to ensure that it is within reason. Is there anything we've missed?
Thank you very much. Honorable Skosana?
Yeah, no, thank you very much, Chair, and good day to everyone. No, we welcome and appreciate the presentation from the LPC. I've got 5 questions from my side. I'll put all of them and then get responses after. Number 1, between January 2019 and January 2025, you receive about 9,671 complaints that relates to RAF, and against 2,622 legal practitioners, and only 280 of them were found guilty. That constitutes about 10.6%, meaning 89.4% were not found guilty. So I just want to find out as to, regarding this 89.4%, is it because their cases were very weak, or they were raising things that are irrelevant, or maybe there's a legal lacuna that makes it difficult for you to find a legal practitioner guilty? I mean 89.4% is quite a huge percentage if all those people are found innocent. So I just want more clarification whether there's a legal lacuna, or just that the cases were very weak, or they were raising things that are irrelevant. Secondly, in your slide 9, you are saying 16% of RAF-related complaints result in a guilty finding. But then again, you say less than 1% of legal practitioners are misbehaving. So can I get clarity? 16% versus, because we are saying 16% are found guilty, but then we are saying less than 1% are misbehaving. What is the correlation between the two numbers? My third question is with regards to the 350 million rands that was erroneously paid as duplicate payment to 101 law firms. According to your investigation, what caused this? Is it a usual thing to happen? Because yes, if we're talking about maybe one a legal firm, 2 legal firm, 5 legal firm, but 101 legal firms all get this duplicate erroneous payment, I think it's something that raises eyebrows. So according to your investigations, what caused these erroneous duplicate payments to 101 legal firms, and that constitute about 350 million rands? And how long did it take for those who were able to pay it back? How long did it take for them to pay it back to the RAF? And then coming to medical legal claims, I'm interested to know on the issue of Nonquba Attorneys Incorporated, whether did you receive a complaint regarding that legal firm? If you did, how far are your investigations regarding this particular case? My last question is with regards to attorneys who don't open trust accounts for their clients. Because the SIU did report to us that there are attorneys that despite the court directing them to open trust accounts for their clients, but they choose not to do. Instead, channel the money to their own trust account. And I think in your earlier presentation, I think you hinted on the matter, but then I think you said something like that does not necessarily constitute an unethical behavior. So can you please elaborate on that? Because I find it sort of unacceptable that a court may make a ruling that a lawyer should open a trust account, and then the lawyer decides not to do it, but then channel the money to his own personal trust account, but then you say it is not necessarily an unethical conduct. Can you please elaborate on that? Thank you very much, Chair.
Thank you, Chair. We will split the answering of the questions again. I will deal with the issue of the Nonquba matter. Yes, we had received the complaints in regards to misappropriation of funds by Mr. Nonquba. The complaint dated back as 2014, 2015, but at the time the LPC was not in operation, and what an initial investigation showed was that they could have been overcharging. But when we took over as the LPC in 2018, immediately in 2019, we then went back to the file and reviewed the complaint, and we also received from the Department of Health, I think in the Eastern Cape, reports that there was monies paid over to the law firm to the value of just below 400 million. We immediately then applied for a suspension on of the legal practitioner, Mr. Nonquba, and when we got that suspension, we were able to recover 120 million from his trust account, which we have then transferred to the Legal Practitioners Fidelity Fund. We have subsequently, after numerous defenses that he has put up in the High Court in the Western Cape, been able to strike off Mr. Nonquba off the roll. I think the process that we are currently embarking in is the difficulty of us having to secure and locate the law firm's accounting records so that we can correctly identify how much was paid over by the health department, how much was attributable to which complainant, how much was paid over to the complainant. We have been struggling for years to be able to get hold of the accounting records, but the matter now resides with the Fidelity Fund as when we transfer the monies, they then deal with the SIU, with the SAPS, and then they will complete the matter. But currently, Mr. Nonquba is struck off the roll. And I'll allow Yako to answer all the other questions.
Sorry, before they come in, may I ask, I'm assuming that the government would know how much it paid out in matters that he was involved in, wouldn't they?
They did give us an amount, Chair, but we didn't know how much he actually paid to the claimants, so we could not reconcile.
Oh, I see. So what you didn't have sight of is how much was paid to which claimant.
Yes.
Okay, now I get it. Okay.
Committee member, if I may respond to the rest. The percentage of complaints that you receive mostly relates to delayed payment of trust money or failure to account. So what would happen as soon as the payment has been made, the attorney would do like an interim statement of account to the client explaining this is the capital. What they would do at this stage, they will normally deduct their fees or a portion of their fees, and they will pay the medical experts that has also waited for a while. So what the RAF would normally tell them is your money has been paid, go ask your attorney. The attorney will not necessarily pay the 75% at that stage, so it will be a lesser amount. So the complaint will be the attorney stole my funds. So the money would not have been stolen at that stage, hopefully never. But the final accounting will only come at this stage now, a year or 2 years later, when the party and party costs. That's the cost contribution by the RAF for the claim, for the payment towards the attorney's fees, and the disbursements will only be paid. So in terms of the rules, an attorney is only obliged and a final payment to client. So most of the complaints relate to the delay between the two because the RAF would have told, we've paid your attorney. They failed to explain to them there's a second payment to follow. And a lot of complaints will say of the complaint. We will authorize an inspection that's done by a committee, not by an official, and then our accountants will go out and investigate to see if there's a problem. So most of the things relate to the non-payment or delayed, and when it's explained to the client, they do understand. But that will normally mean we have to go through the whole process and explain it to the people and provide proof and so forth. So that's the one point. The next question you posed about the 16% of the RAF-related complaints result in guilty fines. My understanding is the less than 1% relate in general to complaints in general. The legal practitioners are misbehaving. So it doesn't relate to the RAF. It's just a general remark. So what we're trying to say is most of the attorneys are conducting the work properly and correctly, and there's really, of course, a small percentage that's not properly attending to the matter and misbehaving. Then you were asking a question about the 350 million rand. So what I could gather, initially 14 complaints was lodged, and if you check the newspaper reports, because that's how we unfortunately got some of the information, about 314 million rand has been repaid since, or arrangements has been, has been repaid. So there's a small percentage that remains outstanding, which has not been repaid or no arrangements has been made. I can just say the RAF proceeded with litigation by the end of 2021, and they're the only listed that 14 firms at that stage out of the 101 has not refunded. So even at that stage, it's not only now being paid, it was paid even before we proceeded with disciplinary action against those that was handed out over to us for investigation. I don't know if you want to deal with the last one, the medical negligence.
Okay. Maybe just to explain the concept of the trust versus the trust account. When the court orders make provision that the money needs to be placed in a trust is a legal vehicle that's used to protect funds. It's different from the trust account of the attorney. So whatever capital is received from Department of Health first must go into the attorney's trust account. That is the purpose of an attorney's trust account, is to receive money that belongs to the client. Once that money is received by the attorney, he can then pay the money over to a trust. So think about it in the form of, let's say, a family trust. You establish a trust that you register with the master, that you might be the trustee, and your children are the beneficiaries. So this is very similar. A trust needs to be created. Somebody is appointed as the trustee for this, let's call it the child. And that person is responsible for making the monthly payments and looking after the well-being of the child financially. So once the money is received into the attorney's trust account, he can then pay it over to the trust. And what a lot of these attorneys have said to us, but we have never received the money by the time that you bring it to my attention, or I've been waiting for the master. I agree with you. If it's a continuous complaint, and as my colleague indicated, we do look at the profile. If you have repeat similar complaints, we start noticing that those trends exist, and then we look at that very closely, because that then becomes a red flag. But that's why I'm saying receiving the money into the attorney's trust account and keeping it there is not an offence. It's once that money is misappropriated or sent somewhere else that it becomes problematic. What is supposed to happen, and I think this is the part that the attorneys maybe for whatever reason do not do, if you see that you cannot establish the trust within the 6 months, they are supposed to go back to the court to ask for an amendment to the court order, and they don't do that. Okay.
Sorry, can I ask sorry, Honourable Skhosana, I'm going to come to you. I just want to understand this party and party costs. Can you explain that in English? It's very pertinent it's extremely pertinent for us. So can you please do that? I'm sorry, Honourable Skhosana. I just want that.
Okay, let me try. So party and party costs, you've basically got primarily 2 scales of cost: party and attorney and client costs. Okay. So party and party.
No. So how does it? Okay. Is it when? Are you gonna go there?
I'm going there.
Okay.
Right. Party and party are the costs that are stipulated in the rules of court. So High Court rules have got a tariff schedule for party and party costs. Similarly, Magistrates Court has got a tariff schedule. Okay. Without going into too much detail, and I'll be honest, I'm not a cost expert, in the High Court tariffs, there's also, it splits down further, scale A, B, C, depending on the nature of the matter that's considered and the severity or the complexity, whatever. What is important to understand is that party and party costs are lower than attorney and client costs. Okay? So generally when a court awards costs to a successful party, it will be on the basis of party and party costs. So let's say, for example, I represent you in a matter, and we are successful in the matter against RAF. The court will say that we are entitled to party and party costs. I can then go and draft a bill in terms of the rules of court, submit it to the taxing master. The taxing master assesses it and says this is the amount that's awarded for party and party costs. Let's assume that we did not work on a contingency basis, right? The amount that you are due to pay to me might be sometimes up to a third higher than party and party costs. And that's been a legal principle in South Africa for very long, that you've got that difference.
I'm asking for a reason. So let me just ask it this way. It only gets triggered when litigant A there's litigation and the respondent or applicant, depending on who loses the case with costs. Is that the only time it happens? In other words, if there's a case, it gets settled, the matter was fairly litigated, there is no order as to costs. So in other words, it's not a routine thing that the courts would say someone should pay party costs. It happens when costs are warranted in terms of the merits of the case and the outcome thereof.
Well, generally, Chair, the loser pays the cost in the High Court.
Okay, thank you. So the reason I'm asking this, and members, please, let's take note of this. We had a presentation here by the Road Accident Fund in March. And there was a list given to us of attorneys, up to 10. And the total amount was 639,101,301. So we're not going to litigate this year, but we'll need to pull this out because I did ask. So the heading said, top 10 attorneys by plaintiff legal and other costs for the period ended 31 December 2024. And I asked for an explanation, and I will ask the team to pull it out for later when we have a discussion. And this matter of party costs, because I asked what other means for those members who were here. I asked, what does other costs mean? And it was said to be party and party costs. And it, given the quantum of this, so we just need to get a better understanding because, and we'll ask the Road Accident Fund to explain this further because these are staggering sums of money. I mean, over 600 million in a year. It's a lot. Okay. But it's something that will then just, because the whole thing around what law firms are milking the RAF out of partly arises out of this party and party cost thing. So the committee now needs to have it broken down to understand how much of that is occasioned by the judge deciding to penalize. Is that how you understand it? So how are the cost orders done? Because I think this is important. We just, at least from your perspective, and it'll give the RAF an opportunity to also explain this.
Penalizing, Chair, would be the attorney-client scale. The party and party is general there, that the loser will pay party and party costs. And then attorney-client is the penalizing, where the judge is now penalizing the defendant for whatever. Yeah.
So please educate us. I'm not an attorney. I'm not a lawyer. What causes a judge to award costs against a litigant, generally speaking? Why do they do that? Why don't they just settle the matter and everybody walks away?
Well, we currently now, and Craig will, because he appears in the High Court all the time. Currently, as you know, Chair, there's been proposals by Judge Mlambo to have matters mediated, and then...
No, I'm asking a different question.
Oh, okay.
In the ordinary course, in terms of the rules of court, why do courts award costs against, it has to be against somebody? Why do they do that? Instead of just deciding on the matter and everybody walks away.
If I may answer, first of all, the rule that the loser pays the cost, which is the default position in the High Court, is a very long-standing rule. It's also common to many comparable jurisdictions. But the basis for it is that if I take you to court and I cause you to incur substantial costs to defend the matter, and then in the end I lose and you win, why should you be out of pocket for the costs that you incurred? Having said that, and vice versa, where my claim against you succeeds, it means that you've put up a bad defense. So one of the assessments that lawyers must make in advising their clients, whether to proceed with a matter or whether to defend a matter or not to proceed or not to defend, is to say, you must remember that if you lose this matter, you could be liable not only for your own costs, which you're then not going to recover from the other side, but you could be liable for their tax costs. But just one last point is that the costs that are taxed usually are only a fraction of the costs actually incurred, because the costs actually incurred are by agreement based on hourly rates and daily rates and so forth, whereas the tax costs work on a tariff, and the tariff is not very generous. So it's almost, sometimes the costs that you recover are significant, but they're not usually significant relative to the costs actually incurred.
No, thank you. Look, we'll deal with the rest of it with the Road Accident Fund. We'll just ask them to now break down the same data that they sent to us, because we need to understand which is which and at which point the ripping off happens. Thank you. Honorable Kusana, I'm sorry, because of this issue, I really had to ask about this thing because it jumped at me from the previous conversation. You had one last follow-up?
Yeah, just one last follow-up. On the 350 million rands erroneous duplicate payment. I think you answered the second part of my question that talks to the issue of paying back the money to RAF. But the first part was with regards to what caused the erroneous duplicate payments in the first place. What led to that kind of a situation? That's the first part of my question that was not answered.
So from what we saw, a large percentage of these came about because of the delays in payment from RAF. So remember, the client might have been awarded damages and is entitled to receive those damages, to have it paid, right? The RAF delays in payment. The attorney, in an effort to protect his client, then executes by way of a warrant of execution. It's become prevalent that the RAF no longer really have assets to attach, so the attorneys would actually attach the bank account. And this is allowed legally. It's common practice, right? It appears that there was delay or a lack of communication between the banks and the RAF in terms of what has been paid by way of a warrant of execution. And then they would go ahead and make the payment as well. So when the attorney sends the sheriff to attach the bank account, a notice also goes to the RAF to say we are issued with a warrant of execution to attach the bank account. And then they would, based on that warrant of execution, go and try and pay the capital or the costs, whichever it might be. But simultaneously, the bank also pays from the bank account. And that communication seems not to have happened. What I do want to say is that this instance of the 100, it's not the first time that it's happened. It's been happening, maybe not at the scale at which it happened now, but it's been happening for many years. Given the volume of payments that the RAF makes, there's always been duplicate and erroneous payments from the RAF.
Thank you. Honourable Duna.
No, thanks, Chair. Chair, my 10 minutes starts. No, thanks, Chair. Doc, I think my first question, noticing that I think you have 10 practicing attorneys and 6 practicing advocates in your council. I would assume you are part of those who are still practicing, right? No, the chair or the I just want to ask, if a case were to be brought by against one of them, who would investigate it?
It will be investigated by other legal practitioners who are not on the council.
Okay, thanks. Who are not on the council?
Yes.
So the investigative committee, who are part of it?
It is made up of any of the 43,000 practicing legal practitioners.
So how do you formulate it, or do you formulate it on per case basis?
Yes. So we have a panel. We have advertised at the beginning of 2019, and I think recently 2023. We put out a notice to ask for legal practitioners who are practicing to apply to be part of our panels, and there's specific requirements which you must meet. You must have, and we also say that we want some legal practitioners who are specialists, for example, in tax law, maritime law, so that we can group them. So if a matter comes in and it's a matter of a tax matter, for example, we go into that panel, we look for for anyone in the province who can sit in a panel, and we try and mix 2 or 3 legal practitioners and make sure that if it's an advocate who's being complained about, there is always 2 advocates on the panel.
Okay, so in my province, if there's a complaint against me,
yes.
For instance, in KZN, I'm practicing in KZN,
Yeah.
so you go to KZN and look for people who will sit in the investigation committee.
Yes, so the director there who's sitting in Pietermaritzburg does all that without my involvement as the CEO, because I'm a national CEO.
Oh, okay.
Yes.
No, I'm asking this because I'm worried of the issue around the issue of independence and impartiality, of which I think it's what really it's very important when we are performing these types of investigation. And I know that there was from the side of the ombudsman, they at some point they find out that you did not act. You failed to act in public interest, and you also contributed to injustice. I think that was said by Judge Desai. It's Desai, Judge Desai. Can you allude us around that situation? What was happening there?
On which matter, sir?
It was the matter involving attorneys Shootman and Slappet and others.
Okay, all right. The director Gauteng, who's that's his matter, he will respond.
Right. So in that matter, unfortunately, it does relate to RAF-related litigation. What had happened is that there was gross overcharging and overreaching, right, from one of the practitioners in the firm. I think the dissatisfaction that was expressed by Judge Desai comes from the fact that there was a settlement agreement reached with certain directors of the firm. One of the directors have been charged, have been found guilty. We are pursuing him to strike him from the role. At the moment, we are unable to locate him. So we've applied for an order for substituted service, meaning that we're going to publish in the newspaper and we're going to proceed against that practitioner. But just coming back to the dissatisfaction expressed by the judge, it is allowed in terms of the LPA, the Legal Practice Act, that settlement negotiations may be done with parties in instances where it appears that the sanction would not, or the guilty finding would not result in striking or suspension. So as I indicated, I think it was 4 directors of the firm were not directly involved with what this practitioner had been doing. They are still guilty by association because any director of a firm is responsible for what happens in the entire firm. But they were able to show that, they were not that directly involved to the extent that they contributed. So they've been given fines. The firm itself has been given a fine. Those fines have been paid. Let me not comment on the appropriateness of the settlement. I think that is something that has been done already. It's not possible to now go back. The long and short of it is that we need to get hold of that practitioner who was the key culprit and then have him struck from the role.
Thank you. I just want to make a statement to you. Given the alarming prevalence on the corruption in RAF and medical claims, do you acknowledge that the regulatory framework may be inadequate or may be captured by certain interests?
Can I just ask for clarification? When you say the regulatory framework, are you talking about the LPC regulatory framework?
Yes.
Okay. Do you want to? Can I? So, I think we've alluded to the fact that the regulatory framework has issues. That's why we've been asking the Minister for amendments to the legislation. I think it's clear that, firstly, our process is way too tedious. It takes too long, and we need to have the legislation amended to address that. On the issue of the capturing of the framework, I cannot say that there's anything like that. What I can confirm, and I think it's been in the media, we have identified employees who's made themselves guilty of colluding with legal practitioners. And we are addressing those. We've dismissed some of them. Others are still in the process. We've laid criminal charges against them. That, in my view, I don't think is sufficient to state that the LPC processes have been captured. I do not believe it has been captured.
No, thanks, Doc. Because I was asking that question because I was going there. Because I know that you have some of your employees from your side who have been found on the wrong. But thank you. Lastly, on the duplicate payments of RAF, is the Doc familiar with the name Sibongile Mani? A student that was overpaid 14 million from Eastern Cape by NSFAS. Is the case of double payment to lawyers not the same case as that of NSFAS? Given that that young person was given 5 years in prison, and he never said that NSFAS they must overpay him to 14 million. And lawyers as well are being doubly paid. And they are keeping the money. They are not saying, come back, take the money. What is the difference between these cases?
I will just try and answer the question partly. You'll remember that the money that is paid to the LP by RAF does not clarify who it belongs to. What we found on our initial investigations was that the double payment related to one or two or five claimants, and there were monies that were still owed to the claimant via the same LP that should have been paid by RAF. So when you questioned the LP, they thought that this is the amount relating to all the claimants that they have in the database who have court orders which says that they must be paid. So when we then alerted them that no, you were paid for the same claimant twice or 3 times, that was the time when they paid it back. And we can't really fault the LP on that instance because there is no clarity on who the money paid to RAF belongs to.
Sorry, can I just make a request, which I'd made earlier? So I know that for you guys, LP makes sense. For some of us, can you say attorney so that the public, please?
No, thanks. I think because we've engaged on I happen to sit on the portfolio committee of transport as well, and we have went through a serious volume of RAF and where they are speaking about these double payments and how they happen. Usually, Chair, how they happen is that when you attach them, the bank account, usually what legal practitioners do, when they know that they are already on the payment roll, because I think it takes about 120 days or something for when they've made the payment to reach you. Now, when the legal practitioners, it is alleged that when the legal practitioners know that that payment is already on the roll, they then go and attach the bank account. Now they get that money from the bank and then they get the double payment because it had already been enrolled. If you understand this financial system, how they work and the integration with the bank account, you don't make payment today, you receive it, especially given the volume of payment that RAF makes. Now that's how they receive the double payment. In your report that you are saying RAF as well is blaming lawyers to say that they are colluding with RAF staff in making sure that they get these double payments. And I would like to believe I know they have many problems at RAF, but I would like to believe them in this vision, Chair. Because after the lawyers have received this money, they do not return it. And the only difference, if you analyze the case of Sibongile Mani and this one of lawyers, is that lawyers have money to pay it back when they are found. But Sibongile Mani did not have the money to pay back the money when he had been found that she has been overpaid. So I think it's a wrong statement to say that it's correct for lawyers to stay with double money, whereas RAF on the other side does not have money to pay claimants. It doesn't make sense to me, Chair. And I think that would have been my parting shot. And I'm really worried about the issue of interest of that money. Where does it go? Because actually those are proceeds of monies that are received wrong. So according to me, they would have been being paid back to RAF. And lastly, Chair, as a comment, I think it's in the funding of LPC, the way it's being funded. I think that's one of the things that we need to speak about. One, we need to speak about the objectivity, independence of the LPC. Two, we need to discuss the issue of funding of LPC. Maybe it goes back to the regulatory framework of it in order for it to operate effectively. Because it's impossible, Chair, that out of 53,000 people complaints that you receive, only 741 would be strike or roll. That's impossible. It means that LPC doesn't have the adequate capacity to adequately investigate these matters to reach the correct conclusion. I think.
Thank you very much. Do you have a response? And also, can you, on the number, just clarify me, is it 53,000 people complained against, or is it 53,000 complaints? Please mention the number of, can you please do that? But Honorable Maduna's point stands. I just want to make sure we get the content of the presentation correct.
Chair, I was the number. Yalo will confirm just the number. Mine was to deal with the to say that in an as Honorable Duna was mentioning, in an instance where there's clear collusion between an attorney and an official within the RAF to ensure that there's this double payment of fees, that attorney would have rendered themselves contrary to the code of conduct, and I would imagine that would result in a strike off instead of us saying we will accept him just paying back the money. I would imagine, because it would have been a conspiracy to clearly, intentionally ensure double payment, which is different to the example that Mr. Brill had given earlier on to say, I'm a practice that specializes in this. I've got 6,000 files. Here's monies that came into my account, but I can't account to which matter it actually relates to. And then once it's done, then I pay back. So in that regard, it's clear difference between the student who knows your school fees is 50,000, you receive 1.5 million, you then go and buy hair and party with the rest of the cash.
Just lastly, Mr. Maduna, I'm just receiving information that in some of the provinces, the lawyers, the attorneys did reach out to RAF to say to them, we have received additional funds. Please give us bank accounts where we can pay it over. And that communication was not responded to by the RAF. So it's not everyone, Chairperson, that just received the money and sat back and said, well, we have a bonus. They tried to reach out, and there was no responses from the RAF. And this is not the first time that, as Ignatia said, that there were double payments. But you barely get any response from RAF on where to pay the money back to.
So I needed the number. Can you restate the number? We just need to get the numbers correct for the parliamentary record.
53,068 complaints were submitted, received during the period 1 January 2019 to 19 June 2025.
Yeah, know that. But what Honorable Maduna is referring to is a number of practitioners, of lawyers against whom complaints are.
Chair, if you look at page 5 of the memorandum, it says for the period 1 January 2019 to 19 June 2025, the LPC considered a total of 53,068 complaints involving 15,209 individual legal practitioners. Yeah. So the 53,000 is the number of complaints, but those number were only brought against 15,000 practitioners. Okay.
Yeah, Chair, I was saying in terms of, the number, okay, it's the 15,000, and the ones that you striked overall are only 741 out of 15,000. It doesn't make sense, Chair.
No, that's why I was saying your point stands. I just wanted us to get the figure correctly. Thank you. Honorable Mende.
Thank you very much, Chair. Good morning, good afternoon to everyone. Now, Chair, I just want to start where Honorable Maduna left off in terms of the Judge Desai judgment as an ombuds. I want to just know one of the findings, or rather, yes, that he had made was that all the lawyers that were utilized in that disciplinary hearing must not be utilized anymore. Are we still using them? Kulufelo Masedi, Ajay Chagan, Bob Makumva, and Isaiah Mureriwa. Are they still in your panel for disciplinary hearings?
Kolofelo Masedi was actually an employee. He was the legal officer who dealt with the matter. He's since left our employ. He's joined the SIU, in fact. Yes. The other members of that panel, we are still using them. I'll be honest about that. They felt very aggrieved about the comments by Judge Desai. I think whether it is correct for Judge Desai to make a ruling to say that they are not allowed to be used, for me is open for discussion. I don't think he has the power to make that ruling. But yes, we are still using them on our panels. And they perform extremely well.
Did you take Judge Desai's finding for a review? So why do you feel that he is in no position to make such findings, and you don't subject them to a process which is going to either agree or disagree? Why do you feel that the ombuds is meaningless to you?
So it's not to say that the ombud is meaningless. By no means do we say that. And we also have a good working relationship with the ombud. In our view, that was a recommendation made that exceeded his powers. He cannot dictate which members sit on disciplinary committees and which members do not.
No, you are wrong. He is an ombud appointed to make sure that whenever these kind of issues arise, he becomes the final arbiter. And if you are not satisfied with the final arbiter, then you subject his findings to the higher courts so that they decide against. So you can't then come here and blame RAF, who is also arguing in court, rightfully so, for not paying things, yet you are the ones that undermine the ombud's finding and say he has no powers to do such. Based on what? When you have not subjected it to a rightful process, which is a court to go and review the findings of the ombud.
Chair, may I come in? I take the honourable member's point, and I will take it up with council and see if the recommendation must be implemented immediately, or if council decides to review, to send it back for a review.
So all of you didn't know you have to do that? You didn't know the process to review an ombud's
No, we know.
finding. So why was it undermined?
An oversight on our part, Chair.
No, it's not an oversight.
It was.
I'll tell you, it's not an oversight. Chair, we are faced with a situation of let's push everything to RAF and nothing from our part is wrong.
No. That's definitely not the case, Honourable Member.
So just give the member an opportunity to finish her comments, and then you can respond.
Now, can we then get, if it's not on your part and you agree that you were on the wrong, can we get all the people whom were mentioned, which I've just mentioned, to be placed on hold until the court says, I overrule what the ombuds have said?
Chair, if I may, the honourable member is presenting us with a legal conclusion. Now, I must admit I'm not entirely familiar with the subject matter of what the honourable member is raising. But the status of the comments of the ombud are a matter of fact and of law, and we would need to properly consider those as to whether they constitute a matter which can or ought to be taken on review. And I would therefore suggest that we be given an opportunity to look at that and, if necessary, to report back to this committee. I wouldn't want to commit us to a course of action based on what is being presented to us as a slam dunk legal argument when in fact may not be so.
No, it is so, sir. Because then the need for this country to have an ombuds on matters of legal experts or legal issues, there isn't going to be. If the findings of an ombud can just be clearly swept under the carpet or rather ignored and undermined, then there's no need. Because once an ombud says, we are making the following findings and are making the following recommendations, therefore, if you are not satisfied with that, you ought to subject that to another process which is higher than the ombud to make sure that you set aside the findings.
We'll take all this under consideration, Chair.
Meaning which everything that is in the finding cannot be overruled by you, like the utilization of the lawyers that are now sitting in DC having banged and destroyed lives of the people in another DC that they have sat in, and they did not conduct themselves ethically in that DC. Until you subject the finding that they acted unethical, then you can utilize their services. Because the ombud did not just arrive at that conclusion on the basis of vibes. It's on the basis of facts.
So as I understand it, and I too, Chair, am not okay with the facts, but the ombud can make a finding, can make a point of view, and then can even make a recommendation. So as my colleague is saying, unless, and I'm not sure if it was a finding, if it was a point of view, or if it was a recommendation, as I say. I wasn't there at that stage. So we would need to understand what it wasn't stated in the initial background is that the current council only began its term in November of 2024. So yeah, some of the stuff we know from the media. But as I understand, yeah, the ombud can make a report, can make a finding, and then or point of view. And I'm not sure where we are.
I don't know how your carryover was done. If you had taken, when you take over office, someone does a handing over of the work, and that is in your space. Let me go forward with my question.
So, Honourable Member, I'll suspend your time here because I do need to just understand something. So, in the ordinary course, when the ombud makes a ruling, what's supposed to happen out of that ruling?
It obviously depends on what the ruling is about. And I'm just quickly trying to see if I can find the report from the ombud. As you mentioned, it was not on the list to prepare for. so we have, for example, instances where the Ombud made a ruling to say that they're unhappy with how the matter was investigated, and we need to refer the matter back to a committee. And in those instances, we do that. Obviously, there's a process that needs to be followed when the Ombud receives a complaint. And there's engagements between the LPC and the Ombud's office to investigate and to assist with the investigation. But really, it depends on what the matter relates to. I think it's difficult to give a blanket explanation in the absence of context.
No, look, I mean, the reason, I mean, I have the same concern as Honorable Mente, right? The reason I'm asking in the ordinary course, because there was an answer here that said, in our opinion, we felt that they should continue, which means somebody carefully considered the ruling of the Ombud and took a decision to act contrary to what it says. Now, if that's the position, and I'm assuming that it was carefully considered, it can be difficult to provide a reason, having stated what the position is, first of all, and secondly, even for the public to know, okay, so what's the use of this Ombud? If sometimes what the Ombud says is going to carry weight and what the Ombud says is not going to carry weight, it appears, therefore, to be a toothless bulldog. So that's why I'm not allowing Honorable Mente to proceed to the next point, because it remains undealt with. But I now need to understand on a principle. Isn't it that what's supposed to happen, unless somebody feels aggrieved as a result of the outcome, what the Ombud says is supposed to be done? On a principle. And there are ombuds all over the place.
Chair, may I request that we provide you with a written response? And if I can then ask Honourable Mente to maybe formulate a concern and additional concerns that you've got, and we can address those in writing.
If you're not too familiar with the specific case, sure, I'm asking on a principle. I'm asking on a principle. When the Ombud makes a finding and makes recommendation, how do you decide what to implement and what not to? And what's the use of the Ombud if there is no process that guides what then happens?
If I can just use an analogy, because as I said, I'm not familiar with this case. A judge might, in a judgment, express opinions about the competence of an official. But in the end, the only part of a judgment that has binding force in law is the order that is made at the end of that judgment. So if a judge comments that an official appears to the judge to be incompetent, it doesn't follow that that official is now going to be dismissed for incompetence. And that's the analogy we use. Yeah. So one has to look at the statutory framework within which the Ombud works. One has to look at the status of what was before the Ombud, under what provisions of the statute he was operating, and what the status is of the comments that he made concerning whether these people should or should not serve on a committee. You talk about a ruling. I, for one, don't know that there was a ruling. That's the first thing one would want to know. Was it a ruling? And if it was a ruling, what is the status of that ruling? Is it a recommendation that we're entitled to follow or not to follow? Or is it something that is binding on us? That's what we need to look at.
Okay, I'm worried I'm disturbing Honorable Mente's flow, but I am just not satisfied with the answer, because, you see, if the initial answer to Honorable Mente had been, Honorable Mente, we are not completely familiar with what happened here. Can we check and come back to you? My difficulty sitting here is that there was a statement made, and if I've misheard, please let me know, which was, we've taken a decision to continue with these folks, right? That suggests careful consideration to me. I can accept when you say consistently, I'm not familiar with the matter, and therefore I need to come back to you. Now we kind of reversing the answer. That's what it appears to be to me.
Well, Chair, perhaps I can explain it. My colleague and I here, we are counsellors We are not officials of the LPC. So we sit, when the council sits however many times a year, every 3 months or so. Our colleagues to the right of us are officials. They deal with the day-to-day operations of the council. So they know that operationally what has happened here is that those panel members continue to serve. We as councillors, we wouldn't necessarily, well, certainly I was not alive to that fact now. Whether it's something which came across our desk in the last year or 3, I don't know. But the fact is, as I sit here, I don't know. So the initial question was able to be answered to say, yes, those people are still serving. That's a factual question. We then asked, well, don't you have to take that matter on review? And that's when we come in and we say, that is a matter to which we will give proper consideration. So it's not a question of answering and then not answering. They are different questions.
Armand, I am eating into your time, so I'll see how much time I've got in the end to untangle this whole thing. My apologies, but I got stuck at the same place as you. It helps if you switch off the mic when another one is on. Otherwise, the people watching at home can't hear. Thanks.
Thank you, Chair. I will submit the question, but I think Secretary has captured the essence of that question. But in addition to that, don't you find it strange that that DC, which said to discipline the legal firms, the 2 companies, arrived at a conclusion of a fine to certain directors and exclude them from a crime which allegedly was committed by one of them, but say nothing about the proceeds of the clients? What was paid to the clients in that DC? What was the conclusion of the DC where clients are concerned? Because this case emanated from clients who brought a complaint to you that these law firms are embezzling our money and they are not paying us, yet they have received it. And one of the whistleblowers was the insider at the firm, whistleblowing to you as well that what is happening here in this firm is dangerous, is brutal, and is not acceptable. I'm not going to be part of it. Ethically, I'm not agreeing. Morally, I'm not agreeing. It's criminal. So why don't you find it strange that they would arrive at a fine, yet say nothing about the clients?
So the clients always have the recourse to recover their losses. And I know that the majority of those clients are now represented by another attorney who's assisting them in prosecuting the claims.
What recourse is that? Because the clients came to the LPC as their last resort. Fortunately, they had money to even find people to go and draft papers and come to you. For another person somewhere in Mutu, they don't have that money to do that. Now we're talking about people who have money and means to get well-educated lawyers and experienced lawyers to come and present their case to you. Yet you arrive at a conclusion without the very same people who brought these people here.
Sorry, Chair, if I might just ask clarity. When you say we arrived at a conclusion without those people, can you clarify that?
Yes, all of them were not called to the hearing to present, and the conclusion, or rather the finding of the DC, did not have anything to do with the clients, and nothing was communicated to them except that a lawyer was called after the fact and was told this is an agreement. If you disagree, you can go elsewhere.
So, Chair, I don't want to go too deep into the specifics of the matter. The information that I have is that the same attorney representing those clients now was actually present when this matter was considered and the settlement was done. So if there's different information on your side, that's not the information that I have.
Okay, here's what I'm going to propose, Chair. Go back and look at that case and look at the ethical conduct of your own people who are supposed to be helping people. And then you answer us, especially based on this one particular case. There's a second one which Ground Up took to court as well, complaining about a law firm who did not want to be published, yes, in the case of the lottery, Chair. When a publication, which is in the media space, wanted to publicize some of the information with the SIU has got, where he forged signatures on statements, those statements that were accompanying the documents which allowed them to receive monies from lotteries on those cooked up NGOs and everything. He then took the paper to court, refusing that all this evidence must be publicized. And the court again overturned that. But when that particular person went to court, again, when they came to you, to the LPC, again, the LPC did not act accordingly. I will give that case as well. Now, Chair.
All right, so you 4.5 minutes over, but ask one more time and then we're done.
Okay. No, sorry, Chair. Here is one thing that is paining me. Two things I'm going to request from the LPC. They have given us information of a number, cumulative number of cases reported and cumulative number of cases struck off the roll. I'm very much interested on, based on the cases I made, because where I was going is in your report. Based on the cases I've made is that the LPC disciplinary process itself is not pure. And all the cases that were struck off the roll as cases that lack evidence, lack substance or whatsoever, can we get that list of why did you not pay attention to case A and not give it to us cumulatively? Because at this point, it doesn't give us a picture. And then?
So, Honourable, you mean struck off or dismissed in court?
No, dismissed by you and not gone, or even by disciplinary hearing that here there's no case. Because you gave us a cumulative number of cases reported to you. Yet cases that had findings or rather concluded as a guilty verdict or whatsoever, they are what percent? 2% of the number you were given. And for me, it's very funny. Who would take money and all this time to go to report to a body of lawyers, a lawyer that didn't do anything? Isn't that for you very, very funny and worrisome? Because who would be in a business of wanting lawyers to crumble? Law firms must be closed. I don't think that's normal. It's seriously, there would be, yes, some sinister activity around certain law firms, but it can't be that out of 100% of the complainants, from claimants in particular, all of them didn't have substance to a point where only guilty ones are 2%. It's abnormal. It's very abnormal. That's the request I'm making. I don't want a response. I want them to break it down for us. We received the following cases. This was the evidence considered, and this is the verdict that made it to be dismissed. Then the last one is that, the other one is that you are saying RAF is owing a lot of lawyers and all of those things. That's valid. But at the same time, the very same lawyers do not tell you how did those claims get to a point of not being attended to. administratively to the payment. Because RAF's explanation to us is that the lawyers will submit, if, let's say, 10 documents are required, different types, then they will bring 6. And then go back, disappear for 30 days, bring the 7th one. And then disappear for another 30 days, bring the 8th, disappear for another 30 days, then you exceed the time within which the claim was supposed to have been paid. Now, we start actioning the court that RAF is not paying. RAF is not paying us. I don't think RAF will sit
Please
with
wrap
a
up,
cumulative
Honourable Member.
number.
I'm going to get into trouble with the other members.
Okay, that's the last one. I don't think RAF will accumulate money that is impacting on their liquidity to a point where they are not paying people that they are supposed to pay, because this is not about lawyers, it's about the claimants. And all we have been worried about is lawyers not being paid. Why are they not being paid? Because RAF itself will not be paying people who are not worth being paid. So can we get that list explicitly saying lawyer A was not paid, these are the services renders, RAF is owing them? Thank you, Chair.
Are we talking about those lawyers who were retained by RAF to act on behalf of RAF, or lawyers who were acting on behalf of claimants that submitted claims to the RAF?
Yeah, I think it's got a 10-minute timer thing. It's got a 10-minute timer thing, Honourable. So, Honourable Member, can we do this? Can you just explain to the Secretariat will provide the guidance to the LPC? I'm just worried about time for Honourable Kubeka and others.
Thank you, Chair, and greetings to the team from the Legal Practice Council. Greetings to honourable members and greetings to the team behind us. Chair, the LPC, it's an entity that should at all times be beyond reproach. As it stands now, there's a lot that is left to be desired by the public in as far as the Legal Practice Council is concerned. With that being said, Chair, I've got a few questions that I would like to ask. The first question is, has the Legal Service Ombudsman ever found that the LPC was negligent? Is this true or not? If so, what was this regarding? Chair, I'm not sure if I should wait for an answer now or I should carry on with...
Your 10 minutes. So you decide. I think an exchange works better for me, but it's your choice.
Yeah, I think an exchange. I would like an exchange on that front. Has the Legal Service Ombudsman ever found that the LPC was negligent?
Well, in the time that I've been there, Craig, you'll correct me, I don't remember the Justice saying anything negative about us. I do remember there was a matter in the Eastern Cape shortly after we came in, which I don't know if yeah, but since November, I don't think we've had any negative interaction with the judge. I want to take care of it.
Thank you, Chair. I just want to clarify, Honourable Member, that the disciplinary process happens at the provincial councils and provincial offices. So when we sit here and you ask that kind of question, we will not necessarily have all the information that the ombuds would have communicated to the provincial councils in regard to any matter that they might have dealt with. I would like to be given time to just check with all the PCs whether there has been any finding of that nature that you refer to, because the communication is done with the PC, because that's where the DC process lies.
Okay, thank you. I prefer that answer. I think, Chair, here there's a situation where more than 100 legal practitioners have been struck off the roll. The Road Accident Fund was vindicated by the Ombud's report, which lambasted the LPC for failure to hold crooked attorneys to account. Is this team aware of that?
So, I'm not sure if I understand the question, but when you are saying 100 attorneys struck off the roll, to me it indicates that the LPC did act in the sense that that's the substantial punishment, that ultimate punishment that we can mete out is to strike off the attorney from the practicing role.
And then when the ombud says, when the ombud lambasts the LPC for failure to hold crooked attorneys to account, what do you say on that front?
Honourable Member, we're not sure on which report that comment came from. And just on the issue of the RAF and the ombuds, my understanding, Honourable Member, is that when we received the 102 list, we did not receive it as complaints. We just received a list which said, law firm A, this is the double payment. I then distributed that list to the provincial offices because that's where the DC process happens. The provincial offices then requested a full complaint with details of the overpayment so that they can then proceed to investigate the matter. During that time, the LPs which were on the list were alerted of the list and they paid back the money. Now, when it went to the ombuds, which is recent, you will know that out of the 102 firms, only 20-something had their information submitted to the ombuds. Now, that should also raise an eye why out of the 102, only 20-something were provided to the ombuds, because that is the information the RAF then submitted to the ombuds, of which the ombuds then submitted to us, and then we then investigated that number. We cannot just investigate based on someone just saying we did an overpayment. Give us the details, show us this is the overpayment so that we can then be able to investigate. And my understanding was that we received 20-something in terms of documentation, which enables us to investigate.
Thank you. The next question. Has the LPC ever opposed in court a matter where the Road Accident Fund brought a case to strike off a lawyer or a law firm from court?
Yes, there is a matter that I'm aware of. I don't know if I should mention the matter right here. It's the matter of K. Malau. I'm trying to recall the basis for the opposition. And there's a more recent matter of Chweo as well. If you look at the structure of the legislation, the LPC is primarily responsible for taking matters to court. Yes, the Act 43 does provide that any party can take a matter to court for the court to apply an appropriate sanction. We generally, we do not receive a lot of those applications. We would oppose if we think that the relief sought is not suitable, especially with regards to the powers of the curator. Because remember, once the practitioner is struck or suspended, the curator needs to take control of the trust account, and that comes with certain powers. And if those powers are not suitable, then it becomes problematic. On the latest matter of Chweo, the RAF actually brought an application for striking, while the LPC is busy with its own proceedings for striking. It just doesn't make sense.
Okay, thank you, Chair. Chair, the next question. On the, first a preamble. This is now on the medical legal claims. Unscrupulous lawyers, often in collusion with healthcare practitioners who have lodged multi-billion rand fraudulent medical claims against the health department, have been offered a chance to retract their claims or face scrutiny by the SIU. Now, from the standpoint of the LPC, why are they even being given a chance to retract? Why are they not just barred from practicing law in the country? Because these people are known to be, most of them are known to be submitting fraudulent claims. Some of them have done them numerous times before. Why would they not just be struck off the roll in as far as the LPC is concerned? I understand that there's other entities involved and there's other people who are giving them a chance to retract and so on and so forth. But from the LPC's perspective, what is your view on this? Thank you.
Chair, it's definitely not the stance of the LPC to give a chance. Again, as I said earlier on the matter, that any collusion that might happen between LPs and the Department of Health is not something that we have capacity to deal with or to investigate. And the onus is on the Department of Health, just like it did on the Nonguba matter. It brought the matter to our attention, we investigated, we suspended, and we struck off the roll. If these matters are brought to our attention, whether they've been given a chance to reverse their claims, the LPC will not will deal with it as an attorney who's done fraud, and it will be dealt with accordingly. There is no other way around it, Chairperson.
Okay, thank you. Next question. What role is the LPC playing in ensuring equitable distribution of briefs to state departments and SOEs? This is now to black practitioners, to women and attorneys in rural areas.
The LPC does not have the capacity to do that, but you will note the implementation of the Legal Sector Code, which was implemented on September 2024. So there is now currently in place, as appointed by the Minister of Justice, 14-member legal sector Charter Council, thank you, Charter Council, which is now working vigorously to implement the code, engaging with the state, the SOEs and municipalities. I know because I'm assisting them with setting up their infrastructure that they are busy trying to engage with those stakeholders so that they bring to their attention the requirements of the legal sector code. So this is something which is just starting, but it is, of course, hindered by the current litigation by Norton Rose against the legal sector code.
Okay, thank you. There are allegations and reports of mishandling of disciplinary cases and financial mismanagement against the LPC. Right now, I didn't find any information about anyone being formally charged in a legal sense regarding these issues. The LPC is facing scrutiny due to these allegations, which include concerns about spending and failure to act in the public interest. I would like to ask the team sitting in front of me now, what is your comment regarding these allegations, especially on the mishandling of disciplinary cases and financial mismanagement?
Sorry, can I offer you the opportunity? Just ask all your questions because you're over, and then at least you can get your answers.
And then I'll ask one more, Chair. It's fine. In the light of the LPC's decision to drop disciplinary charges against certain advocates and lawyers, does the LPC concede that such decisions risk reinforcing the public perceptions that the LPC is selectively punitive and often harsher towards black legal practitioners, particularly those seen as outspoken or aligned to or with the transformative agenda causes? And how does the LPC respond to widespread concerns that its disciplinary processes are weaponized against transformative agents while others escape scrutiny? Thank you, Chair.
So on the allegation of the mismanagement of the disciplinary processes, I think we've already stated to this committee that we agree that there are shortcomings in the disciplinary structure or the processes that emanates from the legislation. That coupled with the volume and the staff capacity does cause issues, right? We know that there had been allegations in some of the provinces of staff being involved in colluding with practitioners to fix the outcome of disciplinary processes, and those matters were subjected to internal disciplinary. For example, in Gauteng itself, we conducted a forensic investigation. At that stage, we didn't find anything relating to the disciplinary processes, but we found in some of the other departments. And as things stand at the moment, if memory serves correctly, we've already dismissed 4 employees because of that misconduct and the collusion with attorneys. Look, I don't think we're saying that we are perfect. We are not perfect. There are shortcomings, but we are addressing those. I don't know if the... Okay. Maybe on the... Yeah.
On the allegation of weaponizing against certain practitioners who are viewed as outspoken, that perception would be based on a misconception of how the LPC works. First of all, as has been mentioned several times today, discipline is not a function which happens at LPC level. It happens at provincial level. And it in fact principally happens at official level. In other words, it's the legal officer who receives the complaint, assesses the complaint, decides whether there must be an investigation committee. There's then an investigation committee appointed. That committee then investigates, asks the practitioner for his or her version on the complaint, assesses that, decides whether that investigation committee then decides whether it must go to a disciplinary committee or not. Then the disciplinary committee is appointed, and then there's an opportunity to be heard, and it makes a recommendation. And it's only when there's a serious recommendation, like, for example, or an outcome of, for example, a strike-off, that eventually makes its way via a subcommittee of the Legal Practice Council, which is the Disciplinary Oversight Committee, that it eventually ends up with us at the National Legal Practice Council level. The point I'm making is we do not put our hands down into the operational side of disciplinary inquiry. So we don't say we think you should go for that person but not go for that person. By the time it gets to us, it's been through so many processes involving independent people who are appointed to chair those inquiries. If the practitioner believes that any member of an investigating committee or of a disciplinary committee is biased or has got some kind of interest, they can object to them. There's also a right of appeal, which goes to the ombud. So there's no mechanism or opportunity, nor any evidence, I would suggest to you, that the Legal Practice Council puts its hands into matters and says, you must gun for this one and you must leave that one alone. It's a misconception.
Thank you very much. Is there a question that was not answered?
1 minute, Chair. On that note, I understand that maybe at the level at national, there's no situation where certain people are being plucked out from the crop to say, no, go after this one. But what about provincial level or at the level with which you speak to now? Is there no situation or no case where it seems as though certain people are being told, listen, go after that person, whether it's at a provincial level or even lower than that? Because from a public perspective, from where we stand, that's exactly what's happening. And to say that at national level it doesn't happen, Chair, I don't quite accept that, because there's many other instances that we could go to right now that speak to exactly that. So just on that one, please. Lower than you, is it possible? Is it happening? Yes or no? Thank you.
It would be impossible for anybody to say that at the level of official someone was got at or someone was not got at. Just as you heard that there have been cases of corruption that have been uncovered where officials have colluded with practitioners to look the other way, and so on. We can't say that, but the accusation was there's a perception that the LPC is a statutory body, not that some bent official is acting improperly. That's a different kind of accusation for which you would need evidence.
The LPC is not at national level only. The LPC is a body in its entirety.
Yes, I understand that it is, but the accusations made against the LPC, if the accusation is that the LPC has been weaponized to act against certain people, that is a different accusation to saying that there may be an official somewhere who was got at. Completely different. Just as one corrupt official doesn't make an entire entity, body, government.
One corrupt official does, however, represent the LPC.
Okay, sorry, colleagues. So I think the answer is, I can't say there is no official who engages in that kind of thing. I think that was the answer, and it suffices. I'm not sure we can litigate it any further. Honourable Atkinson.
Thank you very much, Chair. Sorry, is it Mr. Briel? Yeah, okay. I believe you were the panel manager at RAF before they got rid of all the attorneys. And I don't know whether it's fair to ask you this, but maybe you have to put a RAF hat on, but what your view was of the panel of attorneys being discontinued, and whether there actually was any plan discussed or any plan in place for how they would deal with judgments going forward. What was the thought behind it? If you could maybe share that with us, I'd appreciate it.
All right. I mean, that really puts me in a very difficult position, having been an employee at RAF, and I wouldn't want to breach any confidentiality.
All right, okay.
So definitely there was significant discussions.
Mm-hmm.
Maybe I can say that I was not in favour of disbanding for the reason that as much as having a panel of attorneys is costly, it definitely is. I mean, litigation is expensive. I was not convinced at that stage that the services of the state attorney firstly would be suitable or would be sufficient. I think, there was a fairly substantial panel in place. Each of those panel attorneys had several staff members, and those in essence operated as extended legal officers or claims handlers, whatever they were called at that stage. I know for a fact that they would prepare memoranda for settlement purposes, etc. They would assess the claims. They would instruct the medical experts. But yes, they were expensive. I think, just to come back, I can't remember who made the comment much earlier in the day in terms of the names of the firms. So I can't recall the names offhand, and I don't have the list. Yes, and they were big firms, but they were also very small firms who got the opportunity to get into this type of work. And I think the RAF at that stage did a lot of work around empowerment. I know that at ops level, at board level, at that stage, there was always a very big discussion around the spend versus the BEE component. And the allocation of work was also based on the BEE level. So a lot of work was done in that regard.
And was there any plan shared with you in place for when the panel was got rid of, basically, or not?
No, there wasn't a plan in place.
Thanks very much. Thanks very much for answering that. I'm sorry if I put you in a difficult position. More back to the business of the LPC. With regards to touting, how do you deal with that? How do you stop lawyers from touting?
I'll venture and answer, and Yala can maybe add. I think touting is one of those extremely difficult contraventions to actually prove. And you will see that the number of complaints in that regard is few, and the convictions are even fewer. It's almost impossible to prove touting unless you can show that flow of money from the attorney to an unrelated party. and usually that cannot be shown. The other way that they hide it is making use of the services of service providers. Call them runners or whatever the case might be, to collect documents from the hospitals. That is very often a guise for touting, but to prove it is very, very difficult. But we do not condone the practice, and it's a practice that should not exist.
And this is something that has more of a relation to this committee. Just recently, during one of the hearings on the Road Accident Fund, we received a letter from the acting CIO, from his lawyer, instructing us not to mention certain things about his previous employment at the City of Johannesburg. And the lawyer wrote and said that he knew his client very well, and he stipulated what the situation was and what the terms of him leaving his employment in the City of Johannesburg. So our chairperson in the committee basically emailed the Mayor of Johannesburg, and we got a different line from the City of Johannesburg. So the truth was something different. Now, when looking at the things that you can take on lawyers for, I mean, most of them are sort of for financial malfeasance, not problems with their trust accounts or, stealing money or overcharging or whatever. What happens when a lawyer lies to a parliamentary committee on behalf of a client? Because that's effectively what happened to us. So I know I did request that a complaint be sent to you, but I was just wondering what would that be something that's difficult to prove? Well, I suppose it's not difficult to prove because it's black and white. But
the code does provide for the behavior of an attorney and an advocate.
Yeah.
And it's clearly spelled out. You cannot, unless if he did not know and those were his instructions, but if he deliberately lied, the code, it's clearly stated in the code.
Yeah.
And depending on the circumstances, the severity could even lead to being struck.
Yeah. Okay. I mean, I have asked our committee to send the case through to you because, I mean, it is quite a serious case to basically lie to a parliamentary committee on behalf of your client. But anyway, that's a point there, yeah.
Chair, if I may just add, I tried to look for that complaint on our system. I didn't find it on the system in the sense of having come through formally, but I did take note of the reports around that, and the matter has been registered as a complaint.
All right, great. Okay, thank you. And then lastly was just to do with the overpayments. And I think you mentioned the fact that there were a number of the lawyers held them, and then obviously once action seems to be taken, a lot of them repaid the money. Would there be, and I think you said that there are no further steps taken, you don't believe that there should be some sort of disciplinary steps if people didn't want to give you the money back but had to be kind of forced to do that? Should there not be some further action taken against them?
So you'll recall from the memorandum that some of the investigations are still ongoing. What I do want to just clarify, even those who had paid back, some of them we did discipline and applied for striking, for the simple reason they could not show that the funds had been in the trust account throughout. So the fact that they had paid back on its own was not sufficient to safeguard them from prosecution and striking.
Okay, and just a follow-up question on that was, you mentioned that they have to basically pay for an annual audit. Should that audit not have picked up the fact that there were duplicate payments? So what I'm saying is that it does appear that it came from the SIU rather than from audits themselves. So is there not a kind of a little bit of a hole there somewhere, which could be an issue?
Look, it's difficult to say whether an audit for purposes of the LPA would have picked that up. When the trust accounts get audited, what the auditors are supposed to look for is whether the writing up of the accounts are in accordance with the provisions of the Code of Conduct and the rules, and whether the trust balances or the balance in the trust account corresponds with the trust ledgers. So in other words, client A, B, C, D, these are the amounts supposed to be in trust. Does it balance with that's broadly speaking what the audit entails. It also looks at things like your FICA compliance and the like. Whether it would have picked up individual transactions as problematic, it's difficult to say. It could, but it's not designed for that.
Thank you very much. Thanks, appreciate it.
Thank you very much. Honorable Matiwan.
Ngibulise kwesihlanu. Ngibulise nakumalungu LPC nakumalungu la ekomiti. You know, Slalo, I was socialized in the streets of Umtata. I think there is a saying that says that you must master the rules in order to break them like a pro. And in the practice of law, you find that law is ambiguous. And in that ambiguity, there is a gray area in which the law practitioners operate. And you question yourself. I think this question has been raised by Honorable Maduna and Honorable Mente on the independence of the Legal Practice Council. If you have practicing attorneys as members of the council, Chair made an example of a cottage. He called it a cottage industry. That the council seems to be downplaying, and they focus more on misappropriation as an unethical or wrongdoing that should be punished, because that one was foolish enough to get his hands caught in the cookie jar. However, if you look at the issues that they raise, overreaching, overcharging, and failure to account, there is a causal link between those three elements. It starts off with overreaching, which is touting. I come from the Eastern Cape, East London, Mthatha. Through observation, we see these things happening, where there is an entire industry centered around road accident fund claims, medical, legal claims, where touting takes place, which the council is downplaying because members of the council are practicing attorneys, and Mr. Ignatius Braille said that they are business people. So when you say you are a business person, your primary interest is the bottom line and not the public interest. And then you look at, for example, at the Contingency Fee Act, Section 5 of the Act, which speaks about client review. Client review that Act empowers a professional body like the council to review elements of a contingency fee agreement, which you said when you were answering, you said that no, that is done by the Act itself, but the Act in its own does not operate. It is there as a law, but it is supposed to be implemented by the Legal Practice Council. And I ask myself, is the Legal Practice Council doing enough in terms of public education to inform the public? Majority of South Africans, or a majority of cases, a majority might be in Gauteng, but Limpopo, KZN, Eastern Cape, that are in the top 4 of the provinces are fairly rural areas where there are high levels of poverty, where you know when there is poverty, that would be followed by illiteracy. As you had said, that a person who's born poor cannot, I can't recall the example, I think a brain surgeon, you said, the chances of that person becoming a brain surgeon are very limited because of the cycle of poverty that they are trapped in. So I don't know if there is a duplication in the roles between the Legal Practice Council and the legal practice legal services ombuds. If cases should be heard by the legal services ombud, that is complaints from the public. They are taken by the legal services ombud, who is an independent retired judge who will look at the public interest, which the LPC, I feel, does not look into the public interest. They look at protecting the industry. And a revelation that came by Mr. Atkinson next to me, it gives a perception. Once there is a perception, it can become reality. And there is a perception that comes from some of the actions that were taken by the Road Accident Fund to try and eliminate middlemen in the value chain of processing claims for victims of accidents. And part of that was to do away with the panel of attorneys. And Mr. Ignatius Brill, who served in that panel of attorneys, is now in the LPC wearing another hat, who was opposed to that idea of the disbandment of that, because that would be taking food away from the business people who are in the LPC. If you look at, when I mentioned this issue of grey areas, the issue of double payments, which the members of the LPC who are seated here today downplayed. I think it was in the SIU or the Auditor General report that the lawyers are using a loophole in the system to get the double payments. Even with if the medical legal claims and other claims that happen, they happen because there is a loophole. Because these are the people who have mastered the rules so that they can break them like pros. I will stop there, Chair. Thank you.
Thanks, Honorable Matiwane. If you want to respond, please go ahead. I'm just going to say, as someone from the same area, I didn't know whether to agree or to keep quiet about operating in grey areas, given my job. Thank you. Please go ahead.
Thank you, Chairperson. I just want to dispel the fact, Chairperson, that Honourable Member says that the LPC does not act in the interest of the public. That is certainly not the case. That is where we put almost all our money in. I could say 70% of the spend of the LPC is spent protecting members of the public. The issue is it might not be enough. That is the only issue. We don't spend money to even sustain the LPs, the attorneys or advocates, which we possibly could be doing because we see that there is so much poverty in the profession, but we don't have money to do that. We put all our money in legal fees, in striking off, in suspensions, in the disciplinary committees that sit, they get paid for that. When we bring in interpreters so that complainants who are bringing in complaints are able to speak in their native language, we spend money on that. We bring them into our offices, Chairperson, just so that they can be present to put forward their case before a DC. All that money is spent, Chairperson, just to protect members of the public. Chairperson, we're also not downplaying at all the issue of double payments, but we are hearing today there's many loopholes that attorneys are using to get those double payments. To us, the information that was given was that there was a rate of execution and there was a payment done by the RAF. We're not aware of these, plans that are put together by LPs. And if there is such, we will definitely look into that. I think our efforts were concentrated or focused on the fact that almost 80% of the money that was said to be double paid was paid back. And that was what to us was important, in that monies that belong to the public, chairperson, are brought back to the public. And we understood that there was a confusion in terms of lawyers who had delayed in paying. But there was not much of a delay in terms, in my recollection, chairperson, because I was there at the time, I don't think that it was even over a month that these payments were kept by the LPs, by the attorneys. As soon as we got the notice from RAF, we distributed, and those attorneys who were implicated, majority of them were able to pay. In terms of the sanctions also that are given by disciplinary committees, I just want to clarify that we say that, and we do prioritize misappropriation of funds because a member of the public has lost their money. It's not that those are the only complaints that we investigate. We investigate everything. And the only thing that I will explain is that when, for example, there is an issue of failure to account, we find that the attorney is given a fine for that, because we're saying that go and improve the way you account to the member of the public, don't do it again, and the fine is issued. It's in most instances where there is a strike-off or a suspension is because there is misappropriation, but there are other fines, 10,000, 20,000, which are issued to lawyers when they have been found guilty of misconduct, but not all of them are due to lead to a strike-off or a suspension. And even those that are even fined, chairperson and honorable member, you will find them on our list, because every outcome where an attorney is found guilty, we will say what the outcome is. They were found guilty, and this is the sanction, so that a member of the public, if they were to approach that same attorney again, they know that there's been a finding against this attorney. Some of the fines are suspended for a certain period of time. Thank you, Chairperson.
Sorry.
My apologies, Chair. There's just one thing I want to correct. I was not a member of the panel of attorneys. I was an employee of RAF, managing the panel attorneys and medical experts, etc.
Honourable members, thank you very much, and I also want to thank the LPC for being here, for the detailed submissions, and also for responding to the questions and concerns of the members, including those that fell outside of the scope of the discussion. I really appreciate that. This is usually an opportunity for members of the public also to get answers to questions that they may otherwise have, which might have nothing to do with what was on our agenda today. So you've also, same as the members of the committee, together performed a civic duty in that way, in the members asking as well as you responding to those questions, and not saying, this is not what we're supposed to talk about today. We will be in touch with you for two reasons. The first is just to some of those follow-up issues. For instance, Honourable mandated a request or two, so through the Secretariat we'll be in touch with you. The second thing is that we may ask you further questions relating to both medical legal claims as well as the road accident fund, because the important thing that all of us must work together on is the prevention of financial leakage from the public purse. It's great to catch people after the fact and hold them accountable, but my preference is these things do not happen. And therefore, we have less and less and less of these. So what we'd like to see, for instance, is fewer and fewer cases of attorneys even needing to be disciplined, because then we know that we are getting to the right place. And I think it's a responsibility of all of us in the country to do that. But I want to thank you for coming once again, and I want to thank the honourable members for your participation in today's proceedings. Thank you.